The writ petition is dismissed. And yes.
Item number 3, WPC 7708 of 2025.
Petition is disposed of.
Yes.
Item number 4. Item number 4.
I want to read this one second. Can you start with it? How we did it? I mean, I just
Yes.
we start with an observation drawn by the Supreme Court in the recent MADA judgment, the 9-judge judgment. Am I audible here?
Push the button.
Okay.
No, it is not.
No, still not.
Middle. Yes. Is there?
Look, let's get that. I'm a little more audible, you know.
Yes.
Now, I start with a conclusion drawn by the court in the recent MADA judgment, 9 judges bench on mineral rights. Maharashtra judgment. I'll just give the citation. I'll read the 2 paragraphs of the conclusion. So yesterday I was referring to Article 39B. So even
Constitution.
there were 2 judgments when this court, Supreme Court, was looking into the larger bench. One was an earlier judgment in Sanjeev Coking Coal and Ranganatha Reddy. In Ranganatha Reddy, the question was whether a nationalization of a motor transport, which talks about man-made resources. So the Ranganatha Reddy said both natural and man-made resources fall within the ambit of Article 39B. So the 9 judges bench only clarifies it and says we have a certain disagreement about the larger view taken in Ranganatha Reddy. But the conclusions drawn on how do we look at Article 39B is important for our purposes. I'll just read that paragraph and give the citation to your lordship. This how paragraph 229, subparas E and F will have relevance for our consideration. May slowly read that. The inquiry about whether the resource in question falls within the ambit of Article 39B must be context specific and subject to a non-exhaustive list of factors, such as the nature of the resource and its characteristics, the impact of the resource on the well-being of the community, the scarcity of the resource, and the consequences of such resource being concentrated in the hands of private players. The public trust doctrine evolved by this court may also help identify resources which fall within the ambit of the phrase material resource of the community. Next, the term distribution has a wide connotation. The various forms of distribution which can be adopted by the state cannot be exhaustively detailed. However, it may include the vesting of the concerned resources interstate or nationalization, in the specific case, the court must determine whether the distribution subserves the common good. So the word distribution, therefore, I take it that it includes all those regulatory procedures or a framework which will deal with the handing over of a resource or retaining a resource, as the case may be. For the regulatory framework is contemplated in the whole idea of a distribution. Keeping that in mind, let me broadly formulate again the propositions which I went through yesterday. Now, prior to 2015, the Lordship knows in the mining law, mining leases are granted on the basis of an application. First come, first served, and so on and so forth. But then for a very number of good reasons, the state and the government felt now that it can no longer serve the purpose of mineral development in our country. Even though from 1948 we came into 1957 Act, for some reason or the other it remained, probably not focusing on the question, what will be a most appropriate regulatory framework which will advance the interests of distribution and securing the distribution to subserve the common good. So prior 2015 application procedure, post 2015 auction procedure. Now in several other judgments, court has looked into how public property will be better handled by an auction procedure, transparency, accountability, and all that. So when you move into a different regime altogether, post 2015, so before 2015, I believe any data says that you get a mining lease because there is no supervisory regulatory framework, whether you mine diligently or not, is not under anybody's regulatory control or supervision. It has found that for long years, or a couple of years, you don't even mine it properly. So therefore, when you shift to a transparent and accountability procedure, the need for a regulatory framework became so prominent and important. For post-2015, a concomitant regulatory framework which will subserve the principles of transparency and accountability and ensuring this distribution to the common good, I think became important. Therefore, the entirety of those post-2020 amendments, 4A, 4B, 8B, all those, including the rules made under Section 1318, will have to see from this larger point of importance of serving the public interest. I was told that many leases were not even working properly. They don't work for a couple of years. Nobody could probably hold them accountable. But today, the accountability becomes an important factor both for the state as well as for the private lives. So therefore, with the dispensation of the application procedure, the new regime, the public interest, as I said yesterday, is the entire underlying theme in the whole scheme of 1957 Act. And may I read in this context, I can have a copy of the written version. So, okay. The Lordship permission may read a few pages from this written submission. Page 1. The lens through which the Mines and Mineral Development and Regulation Act is to be examined is public interest. It deserves to be borne in mind that the MMDR Act has been enacted with the avowed purpose of ensuring development and regulation of mines in public interest. Kindly see Section 2, and then read with entry 54, list 1(7) schedule of the Constitution. For mineral wealth is the wealth of the nation to be exploited in larger public interest of social and economic development. Submitted that credence has to be given to the public interest consideration underpinning the MMDR Act while interpreting its provisions, all of which converge on various facets of public interest. The expression public interest occurring in both entry 54 of list 1 and section 2 of the MMDR Act indicate that the provisions of the legislation do not merely concern the interests of private individuals, such as owners of private property or holders of mining leases, but more towards the regulation of mines and mineral development. There can be no mineral development without minerals serving other productive ends and purposes. Mere winning or production of minerals is neither mineral development nor systematic mineral development. Dispatch and sale of minerals constitute the other limb of mineral development. The public interest underpinning the MMDR Act synonymizes with the collective welfare of the people and is informed by the dictates of the public trust doctrine. At the same time, the underlying public interest has to be construed in view of the entire legislative scheme, purpose, and object of the enactment. It is generally a settled proposition that all economic activity must serve some public purpose apart from individual gain. In the context of mining, especially the Honorable Supreme Court, while considering the challenge to Rule 8 of the Tamil Nadu Minor Mineral Concession Rule, observed in so and so, so and so. Rivers, forests, minerals, and such other resources constitute a nation's natural wealth. These resources are not to be frittered away, exhausted by any one generation. Every generation owes a duty to all succeeding generations, develop and conserve the natural resource of the nation in the best possible way. It is in the interest of mankind, the interest of the nation. Recognized by Parliament, Parliament has declared its experience in the public interest. The Union should take under its control the regulation of mines and development of minerals. I stop here for a minute, and where will anybody can draw a line? What is regulation? What is not regulation? What is excessive regulation? What is reasonable regulation? I'll just come back to it. So we've already referred to its salient provision. The public interest which induced Parliament to make the declaration contained in Section 2 has naturally to be paramount consideration in all matters concerning the regulation of mines and development of minerals. Parliament's policy is clearly discernible from the provision of the Act, is the conservation and the prudent and discriminating exploitation of minerals with a view to secure maximum benefit for the community. Is a clear signpost to lead and guide the subordinate legislation authority in the matter of making rules. That's what precisely happened in the context of Rule 12A. Now, further, the Honorable Supreme Court explained in state of Maharashtra was so and so, and the 7-judge bench has approvingly taken note in state of Gujarat was so and so, that while striking a balance between a right of individual and right of citizenry as a whole, a financial loss caused to individuals becomes insignificant if it serves the larger public interest. I'll in due course also look at, but in the context of taxing law, a mere harshness is no ground for the court to say this will be struck down. And there are cases where the courts depart from a strict rule of construction to a more liberal rule of purposive construction. Then Article 39b, it should be Article 39 within brackets small b, scheme and philosophy of the Constitution calls upon the state to distribute the resources, both man-made and natural, as a subserve the common good. Distribution connotes regulation. What all would subserve the common good can be matters of regulation. The MMDR Act is in aid of such distribution of resources as to subserve the common good of social and economic development, as long as the regulatory framework under this law is seen as subserving this common good of the optimal utilization of natural resources. It shall be taken that the purpose of the law is served. He therefore submitted that what needs to be examined in the present case is whether the provisions impugned in the present proceedings have been enacted in furtherance of this principle of ensuring regulation in public interest. Then, since Section 2 of the MMDR Act is a declaratory provision, the thread of public interest runs through all the provisions of the MMDR Act and the rules framed thereunder, which is a guiding light for the government to frame rules, regulations, etc. For regulation of mines and development of minerals, in order to meet the object of public interest, the state holds minerals in the trust of the people of India. The idea of public interest cannot be frozen, and it is to meet the changing demands of the growing economy that the MMDR Act has been amended from time to time. In today's economic reality, public interest in the context of mineral resources has two primary facets: sustainable development of minerals to ensure intergenerational equity, and sustained development of minerals without any disruption to downstream industries whose development and growth is dependent on these minerals. Accordingly, the 2020 Mineral Law Amendment Act was enacted to insert sections 4B and 8B, and subsequently amended in 2021 with the Mines and Mineral Development Amendment Act 2021. Submitted to the Mineral Law Amendment Act 2020, inserted 4B, 8B, and 13(2)AA into the MMDR Act with the avowed object of maintaining the sustained production of minerals and avoiding any gap in the supply consequent upon expiry of a large number of working leases. 2020, prior to 2020, it happened like this. Large number of leases will expire. How do you take stock of the situation today? The aim is continuity of supply and not mere extraction which is hoarded or stockpiled. I place strong emphasis on hoarding and stockpiling. It's further submitted that it is imperative to have joint and purposive reading of the phrases maintained sustained production of minerals in the country as used in section 4b, along with commencement and continuation of production as used in section 13(2)AA. The use of these phrases indicates a legislative purpose that necessarily embraces measures directed at actual offtake and dispatch, and otherwise a production requirement would be hollow and would permit stockpile. It would therefore be only legitimate and within the legislative scheme to prescribe dispatch conditions as necessary incident of continuation of production. These sections were introduced to overcome the expected shortage in supply of minerals in the country due to the expiry of leases under Section 8A6 of the Act, and to ensure seamless continuance of mining operations in public interest by preventing artificial disruption of supply of raw materials to the downstream industries. Then subsequently, therefore, with the 2021 Amendment Act, the terms production and dispatch were used essential subject matter to the present dispute, were also introduced in MMDR Act. I'll come back to definition a little later. I'll just read a few more paragraphs in pages. Para 13. It will be noted that production is defined not simply as an activity of winning mineral, but winning or raising mineral so as to remove them from the leased area. This judgment Gujarat part is in the context of how do you read an Article 31A(1)(a) as it then stood. Couple of paragraphs in the beginning as to what are the factual context in this case. Paragraph 3, there was a fact leading to the appeal as follows. So-and-so originally had a perpetual lease from so-and-so, and the owners of the mineral rights for excavating white clay from the area lease and be taking it away. Lessors entered into an agreement for executing the perpetual lease. However, did not execute the lease. The possession or the leasehold land had been delivered. So then ultimately, the lease was executed in November 1951, execution of a decree. Then para 4, the original lessee transferred his right, title, and interest in the lease to the appellant in 1954. On September 1960, the controller of mines modified the terms of the lease after following the procedure laid down for modifying the lease under the 1956 rules, which continued to be enforced in view of Section so-and-so Act. The modification, whether the period of lease was reduced to 25 years, and the further renewal was to be regulated in accordance with the law and rules in force. So these modifications were challenged. Now, kindly turn to paragraph 10. So that's the factual context in why the court goes into this question. The actual lease executed in 1951 is executed in pursuant to the aforesaid agreement of lease. Lease also says, besides, according to the terms of the said agreement, within the period of 3 years from the date of the agreement, you continue excavating clay from the said land, and if you abide by the other terms of the agreement, then in it even you were given right to get us from executed a permanent lease. The terms also practice the same as further mentioned in the agreement. We are therefore of the opinion the lease in favor of so-and-so will be granted in 1939. Execution of the lease in number 51 was only to give a formal shape. The lease in suit, therefore, is a lease which comes with the expression of existing mining use within Rule 2C of the 1956 rules. Then I kindly turn to paragraph 14. Para 13, subsection 2 of section 7 of the Mines and Mineral Development Act 1948, referred to as shortly as the 1948 Act, provides the rules for under subsection 1 for the purpose of modifying or altering the terms and conditions of the mining lease, will provide for the payment of compensation for the other party would be benefit for the proposed modification, alteration, and all that. Then paragraph 14. Rule 9 provides for the payment of compensation to the lessee where the area is reduced. The amount of compensation will be determined in a manner in accordance with the principles set out in Rule 10. Clause so and so provides that determining the compensation, control and tribal will have regard to the fact that no compensation payable in respect of reduction of the period of lease. Then 50. Article 31A1E provides, notwithstanding anything contained in Article 30, no law providing for the extinguishment or modification of any rights accruing by virtue of any agreement, lease, or license for the purpose of searching for or winning any mineral or mineral oil, or the premature termination or cancellation of any such agreement, lease, or license shall be deemed to be void on the ground that is inconsistent with or takes away or abridges any of the rights conferred by 14, 19, or 31. It is said that the lease in favor of the appellant is not for the purpose of merely winning of the mineral, but it's for the purpose for other purposes as well. That is, for the purpose of extracting the mineral and taking it away. And that, therefore, this provision does not cover the case of modification made in the lease. It's heard that the winning of mineral means only getting at the mineral in order to make the mine workable, and does not include the right to work the mine thereafter and to carry the mineral away. Reliance for such interpretation is played in some English cases. It was held in so and so that the expression win is in that case meant to put the mine in a state in which continuous working can go forward in the ordinary way, meaning was adopted in so and so. Then kindly turn to paragraph 17. The expression to win interpreted in the English cases was in respect of the context of the expression used in certain leases. The expression winning in a constitutional provision so and so should be given a wider meaning, as the constitution makers would be using it to cover cases which deal with the obtaining of mineral, and in that case, that wider meaning would be to get or extract the mineral from the mine. The object of the constitutional provision was to make the law providing for extinguishment of modification of leases, etc., in connection with mineral rights immune from the provision of Articles 14, 19, and 31. There could be no logical reason for not to cover the leases which allow the working of the mine after the minerals in the mines had been won, in the narrow sense that is making for such arrangement which would allow the working of the mine. Modifying the provisions of any lease merely for making arrangements for the working of the mine could not be effective in making the law free from the requirements of the various minerals in public interest. Modification of the leases governing the working of the mine could be necessary for the public interest. Section 2 so and so declared it expedient in the public interest that the union should take under control the regulation of mines and the development of minerals to the extent thereafter provided. I understand that if Article 31A deserves such a wide reading, I don't see any reason why Section 4B should not receive such a wide reading. Because 4B has been brought in to be in tune with this kind of constitutional understanding, particularly 39B, paragraph 19. Our attention has been drawn to the use of the word winning along with other expressions necessary for the proper working of a mind, the acts and rules. And the urge that the word winning has been used in a narrow sense. In the context of the acts and rules, the legislature, the rulemaking authority, had to use all possible expressions for the purposes of the mining leases so that all conceivable types of mining leases could be covered by the provisions of the enactment under rules. Mining lease, according to so-and-so, means a lease granted for the purpose of searching for, winning, working, getting, making merchantable. Making merchantable means dispatch and nothing more. So carrying away or disposing of mineral for the purposes connected therewith, and include the exploring and prospecting license. The definition is very comprehensive and deals with the object indicated earlier. I submit with great respect, Section 4B deserves a similar consideration, and any other consideration would probably defeat the whole purpose of the law. Now, we go back to my written submissions at page 5, paragraph 14. If the interpretation sought to be given by the petition the word production is accepted, then it will lead to a storage and hoarding of mineral only, which in turn will create shortage of supply of minerals downstream industries, apart from encouraging price escalation. Now, for some of them have been all previous lessees. So they have several leases with them. So I have a lease which doesn't produce much. I supply from that. I'm able to control the market and the prices. I won't supply from the other mining leases I have not done post 2021. So I'm able to manipulate the market conditions accordingly. So does the law intend to give this kind of a leverage to manipulate market conditions? I think the answer would be obviously no. So para 50, it is further submitted that the definition must also be construed in the context of section 4b and section 8b, which emphasize on sustained production of minerals in the country, which would necessarily lead to the conclusion that the production and dispatch to ensure seamless supply of minerals in the country are both the intent and purpose of the legislature. The petitioner cannot therefore seek to rely upon the term production only. It's further submitted that accepting a narrow construction belongs by the petitioner, product that is production alone and dispatch is outside the legislative scheme would lead to absurdity, as it would enable a new lessee to mine but refuse to allow the commodity to reach the market. Our stockpile, defeating the statute's express objective of ensuring supply of minerals in the country. Well settled, the courts do not uphold construction that makes purpose of the statute nugatory. Further submitted that the expression production in isolation may connote mere extraction of mineral. That's why I read out Gujarat Pot in this case. However, context and legislative purpose demand a purpose-driven functional interpretation. The aim is not merely extraction for stockpiling, but ensuring continuity, availability, and supply of mineral produce, with a statute to permit extraction without any accountability for dispatch or offtake onward to the market. The risk of hoarding, supply disruption, price distortions, and subversion of the statute's object would arise. That would lead to an absurd result and frustrate the legislative aim. Therefore, it's submitted that in the light of this amendment, the Rule 20 was also amended. I'll come back a little later. Then kindly turn to paragraph 20 for a minute.
Is there any restrictions either in the Parent Act or in the subordinate legislation that whom you can sell?
No, let me put it like this. I thought let me complete this narration before I come to Rule 20. My object is looking at this from this point of view that what is the constitutional and statutory foundation or the framework from which the court would look at the entire matter. So there's a twofold challenge in the petition. First, they say the demand notice is illegal, but they don't seem to be in consonance in tune with Rule 20. But if they seem to be so, then I'm showing it to strike at Rule 12. I want to challenge Rule 12.
No, I was just trying to figure out the situations because I have also
Yes.
in your the written notes of argument,
Yes.
you have also quoted the definition of a dispatch and a productions as
Yes.
well. And then the entire, I think, the endeavor is to emphasize the word the public interest and also to serve the demand which has been created in the market.
Yes.
And there is a seamless supply
Absolutely.
of those commodity to them.
Absolutely.
That will not also ensure the fair price to be there,
You're
but
right.
also the artificial or I would say by some act create a scarcity or something of that kind which
Correct.
will really affect the economic
Correct.
development, because many sectors they require those commodities or the minerals to make a final product, so that I can understand. So in that event, when you talk about the production, you talk about that production in the sense of regulating, dispatching, selling, but should not be restricted only to winning.
That's right.
There's an expansive
That's right.
definition.
That's
There's an expansive definition. So is there any dispatch? Because the dispatch word which is defined says that it has to be removed from the leased area. It does not talk about how. It may be a weird thinking that has come, that if somebody, can I use the word?
Your Worship,
It's a harsher word. And unscrupulous mining
Yes.
lessee
Yes.
may circumvent this particular provision in a different way.
Yes.
So one has to find out the legislative intent
Yes.
and the avowed object which is sought to achieve.
Your Lordship, right.
This is what is one of the
That's what I'm endeavoring to
That
make
is
good.
what I was saying, because
Yes.
the dispatch means, the definition means the removal of the minerals or a mineral product from the leased area.
Uh,
And then it says includes the consumption of the minerals and the mineral product within the leased area. That's a captive mine.
Captive mines.
It's no difficulty. This is
But that cannot be excluded.
latter part.
Correct.
So this has to be
Correct.
there.
Correct.
The first part, there are two components
Yes.
of the dispatch or removal from a leased area. Still, it can be circumvented in many ways. If there is no regulatory process that whom you will sell, who are the end users?
Therefore, in the entirety of the rules, various schemes of the rules, we are talking about. I'm sorry. In mind, or good old days when you go and bargain with a private landowner and say, "Give me your occupancy rights, and then I do mining." We are not talking about that era at all. We have moved away from that era. If you look at corpus juris secundum, we will talk about those kind of cases.
Yes.
So we are not talking about these are merchant mine. They can sell it to anybody they want, and the entire corpus of several rules framed into that. We'll find the sale. There is a continuous watch on how much of sale we affect.
That's true.
So therefore,
the question is not of sale. Actually,
no, I'm saying
the word is the dispatch.
The dispatch means the removal.
Production and the dispatch means the removal of those.
Correct.
From the leased area means the demised area, which is into the lease.
I brought on to your last subsection. But if the controversy in this case about am I departing from the definition of dispatch and asking to do something which is not removal, then there is an issue. I am not getting into the controversy at all. There is no such big act being undertaken now. All that I'm saying is the production, dispatch, they're all continuous, seamless stages in the entire activity of mining operations. So even if the word dispatch, production dispatch is not used in section 4B, it conveys the entirety of all those operations.
I understand.
That's therefore we are.
I was just thinking what is really going around in my mind, just to understand and have more clarity on that in this regard is that if you have to consider the definition and the several provisions of the Act in the perspective of the public interest, as you have been emphasizing thereupon. And the object it sought to achieve is that there should be a continuity in supply, there should be a seamless, the transactions that should be done. Then in that event, one has to understand the definition. Equally, you are, I would say, the propagating a particular the point is
Yes.
that so far as these rules or these acts are concerned, it has a blending both a substantive right and a fiscal
Absolutely.
part of it.
Absolutely.
Both. And in case of a fiscal, as you know, even if it appears to be a harsh, it has to be accepted.
Correct.
What is that legal maxim? Sed lex or this?
Duralex.
No, that's why
Lex or
in Atyabadi case which came from this
those
court.
legal principles are still there.
Yes.
If the law appears to be harsh, it has to be accepted.
Yes.
In that way. So I was just thinking whether it has really achieved the avowed object. If we give a very, very strict and literal meaning to each of the expressions and the words which are used in the statute,
Yes.
or some latitude of adopting a purposive construction
Yes.
is also to be achieved.
Yes. Let me
May I
address
give
your.
an example also, which is hovering around my mind,
Yes.
that something can be circumvented that may not be apt, but something can be done. Does it really achieve those objects?
Yes.
Dispatch indiscriminate,
I'll come back.
not reaching to the market.
Exactly. Exactly.
What will happen?
So as I said,
It's a removal done.
Yes.
Not reaching to the market.
Suppose the legislature, the delegated legislator, while enacting any rule in purported advancement of Section 13 or Section 18, in the case may be, he says, I give a different meaning to the word dispatch. And it's not only removal, but removal subject to the following conditions. Or add something, the word, a definition there. Then the controversy would be probably something else.
True.
But today we are not in that controversy at all. We are in a slightly different terrain. The terrain is, what is the scope of Section 4B? If Section 4B, because there is a corresponding amendment in Section 4A, production and dispatch are brought in subsection 4 and then for 5 or 4A, the whole controversy has been generated. I say it's an artificial construction. Section 4B is what has fallen for consideration by this Honorable Court. If Section 4B, the sustained production of meaning of minerals in the country, will receive the utmost widest important meaning and interpretation, then it will include production, dispatch, with or without the definition in the Act. So the definition is not a difficulty at all. You may go along with the definition of production and dispatch. But therefore, 4B will receive the utmost and the widest constructions possible. In order, I'm trying to endeavor that it will receive and probably serve the public interest purpose of the entire Act. Therefore, I am probably would seek the indulgence of the court that we may not look at what exactly the definition means, but whether within those definitions, with the aid of those definitions, Section 4B would probably be construed in that light of the definition. The argument was that, 4B has these insertions in 20 and 2021. 4B does not have them. Look at 4B very narrowly. I mean, I am not able to understand that argument. Therefore, 4B is a bedrock. Is a bedrock for enabling the whole government, a delegated legislator, to enact such rules as would enable the object and securing the object of sustained production of minerals in the country.
True.
So where would be a room for the court to come and say, this object will be served by the following regulatory framework, this object will not be served by the following regulatory framework. Therefore, I'm only trying to endeavor to say that look at 4B and look at that. Let me read a few more paragraphs here and come back to my. I was at paragraph 20 at page 6 of this, just to give an indication. In one of the petitions, because by the time 2018, 2019, unfolded, there was endeavor on the part of many leaseholders to have a very high level of production, and they did that. And then they did that. They did not have any difficulty. It was not that they were not doable. So I'm going to use the word, if something is not doable at all, then a regulatory framework asking you to something which is not doable will probably fall into Section 56, impossibility of performance. So it is not a case where they come and say on facts demonstrate this is not doable at all. So let me look at paragraph 20. Then the petitioner is misplaced and misinterpreted cannot be any possibility there being no demand in the country at any given point of time. Iron and steel are the driving force behind industrial development in the country. The vitality of the iron and steel industry largely influences the country's economic status. The mining of iron ore, an essential raw material from iron and steel industries, arguably of prime importance among all mining activities undertaken in a country. You stop this regulatory framework, we look at how our social economic development will come to a grinding halt. The iron ore production data from the year 2001 till 2024-25 is given below. I don't know whether Jamshedpur would have grown the way it is today without dispatch having ever happened there. So kindly turn to page 7. So 2001 onwards, 2001, and all India production data and is 80.59. Odisha contribute to 14.38. So we have the percentage of contribution of Odisha in the last column in the years from 2000 onwards. So kindly just look at the last years at 19, 20, 21 onwards at the bottom of that page. So
It has exceeded half.
yes. So therefore, what I'm talking about the doability. I mean, it's so evident, so self-evident. So 19, the total national production is 206.49 million tons, and Odisha contributed 54.78%. So it goes on increasing, 60%, then it somewhere in 2021 now, because of all this, says 50, and then it has a even tempo thereafter between 50 to 55. Therefore, when the law came in and said, look here, kindly turn to paragraph 21. From the above data, it may be inferred that Odisha is the backbone of iron ore production in the country. It contributes to more than half of the total production of iron ore in the country. It stated that the consumption of steel in the country reflects the prosperity of its economy. To fully harness its growth potential, the country requires creation of infrastructure such as airports, railways, bridges, ports, real estate, manufacturing, etc. In all of this, indigenous production of steel will be extremely crucial. I'm passing here for a minute. We are told now today several other minerals, bauxite. India has a rich bauxite mineral wealth. Australia also has them. But there's a global competition. So we seem to be importing a lot of bauxite. It's like copper. So despite we have all this mineral wealth, we're still doing a lot of importing. So why should we do that? Then in order to increase the domestic steel production, the central government has come out with the National Steel Policy 2017 to facilitate faster growth and development of steel industry in the country. The policy envisages to domestically meet the entire demand of steel and high-grade automotive steel, electric steel, special steel, and alloys for strategic applications. Focusing in the policy project, crude steel capacity of 300 billion ton production of 250 million metric tons, million tons production, and a robust finished steel per capita consumption of 158 kilograms by 2030-31. So how will this be achieved if I don't have a regulatory framework? And the regulatory framework does not include a supervision or a control on dispatch. Therefore, it can be inferred that in order to cater development goals, continuity of production dispatch of the iron ore to the downstream industries for various aforementioned projects is a sine qua non. Now, yeah, keep it steady. I may, before I come to some Swadeshi jurisprudence, I may have to go to some Videshi jurisprudence of the Lordship's permission. So I'm going to place some few American judgments here, which this is Roshan versus Ward, 279 US 337. I just look. In the first page, a state statute making it unlawful to sell at retail in any store or established place of business any spectacles, eyeglasses, or lenses for correction of vision, unless a physician or optometrist is in charge of the place of sale and in personal attendance at it, though not providing specifically for an examination by the specialist, is valid. The question was whether you go beyond your regulatory framework to ask the physician or optometrist to do also the work of.
Without having your eyes
Correct.
checked
So
up
every
and
case
all,
I
does
must say, should the optometrist be there at all to do some service? That is answered. The Lord should kindly attend to paragraph page 4 of this judgment. The complainants sell only ordinary spectacles with convex spherical lens which merely magnify and which is said can do no harm. The customers select for themselves without being examined and buy glasses for a relatively small sum. It is said that most of the cost of employing an optometrist would make the complainant's business impossible, and that in the common case of eyes only grown weaker by age, the requirement is unreasonable. But the argument most pressed is that the statute does not provide for an examination by the optometrist in charge of the counter. This, as it is presented, seems to us a perversion of the Act. When the statute requires a physician or optometrist to be in charge of the place of sale in personal attendance at it, obviously it means in charge of it by reason of and the exercise of his professional capacity. If you assume that an examination of the eye is not required in every case, it is plainly the duty of the specialist to make up his mind whether one is necessary and if things necessary to make it. We agree to all the generalities about not supplying criminal laws with what they omit, but there is no canon against using common sense in construing laws as saying what they obviously mean. What they obviously mean. Moreover, as pointed out below, wherever the requirements of the Act stop, there can be no doubt that the presence and superintendence of specialists tend to diminish in evil. A statute is not invalid under the Constitution because it might have gone farther than it did, or because it may not succeed in bringing about the result that it tends to produce. I'm talking about section.
To you.
That's right, section 4B. Therefore, it could have gone a little further and said, sustain mining production, meaning thereby. So the meaning thereby is absent, therefore, you cannot supply that meaning to this wide, worded expression. Therefore, it's in the contract law, we had this, the obvious bystander. So when two contracting parties and say, oh, that's what I meant. So something so obvious as that, it doesn't have to be so explicitly stated in a contract. So this is what the reasoning, I think, that will probably weigh with the court in a case like that. Yeah. We have several statutes where definitions and some words used with lack of, if possible, little precision or not being able to accommodate the wide meaning that may come from time to time. For instance, we had one old English case, the word telegraph. The Telegraph Act we still have. Telegraph, they said it will include a telephone. The telegraph will include a telephone. So, of course, the telephone was not there when telegraph was invented. So scientific terms may also undergo certain changes owing to social, economic, and scientific developments. Therefore, here is this case concerns about retrenchment. Kindly turn to paragraph 13 at running page 675 of the report. There is no doubt that the Act itself provides a dictionary for the words used. We must look into the dictionary first for an interpretation of the words used in the statute. We are not concerned with any presumed intention of the legislature. Our task is to get the intention expressed in the statute. Therefore, we propose first to examine the language of the definition and see if the ordinary accepted notion of retrenchment fits in squarely and fairly with the language used. What is the ordinary accepted notion of retrenchment in industry? With occasion to consider the question and so on, so on, so. So retrenchment connotes an ordinary acceptance that business itself is being continued, but that a portion of the staff or the labor force is discharged as surplusage, and the termination of services of all the workmen as a result of the closure or the business cannot therefore be properly described as retrenchment. It is true the observations made in connection with the case where the retrenchment took place in 1941, and we specially left open the question, the correct interpretation definition in section so and so. But the observations do explain the meaning of retrenchment in an ordinary acceptation. Let us now see how far that meaning fills in with the language used. We have referred to the four essential requirements, the definition. The question is, does the ordinary meaning of retrenchment fulfill the requirements? In our opinion, it does. When a portion of the stats, so I skip that part of it and kindly turn to the next page. Just after placitum, just above placitum B, with a B,
Yes.
with a sentence beginning. In the absence of any compelling
Yes.
words to indicate that the intention was to even to include a bona fide close to the whole business, it would be thing by diversing the expression altogether from its context to give it such a wide meaning as is contended for by the learned counsel in the response. What's being defined, retrenchment, that's the context definition. Artificial definition may include a meaning different from or in excess of the ordinary acceptance of the word, with a subjective definition. There is something compelling words to show such a meaning different from an excess of the ordinary meaning is intended. Then paragraph 14. There's another way of looking at a problem. Let us assume the definition clause is so worded. The requirements laid down therein are fulfilled, whether we give a restricted or a wider meaning. To that extent, there is an ambiguity and the definition clause really capable of more than one interpretation. What then is the position? We must then see what light is thrown on the true view to be taken of the definition clause by other provisions of the Act, or even by the aim and provisions of the subsequent statutes amending the Act or dealing with the same subject matter. I place emphasis on that.
Let's see.
If you look
Borrowing and externally.
That's right. You look at the word dispatch in production used in section 4A, why they were brought for a certain purpose other than 4B. Look at how it's been used in the same context in Rule 12A, things like that. Right? The question in this issue in this case is about the meaning of the words bought and sold, and how do you really construe them? Kindly turn to paragraph 8. Because there's a notified area and there's sold or transferred within the notified area, outside the notified area. What will actually constitute the bought and sold? On these facts, the district municip held the property and the goods having passed the destination. Sales took place outside the notified area, and therefore the fee charge was illegal, as Section so permitted such levy on goods bought and sold within the notified area. An appeal by the committee, the subordinate judge held set fee was a tax on sales outside the notified area in the state and was not therefore warranted under so and so. It seemed that in both the courts, the real issue was lost sight, namely, whether goods in respect of which the fee under section was levied were goods bought and sold within the notified area as envisaged by the section. In the High Court, however, these questions canvassed were, I just skipped that question. Kindly turn to paragraph 11. Before that, may I request the Lordship to also quickly go through paragraph 10. At the bottom of paragraph 9, how the Supreme Court looks at it. In our view, last sentence in paragraph 9. In our view, the High Court approached the question from a correct angle, and therefore there's no question of it having allowed a committee to change its case. That being the position, the next question is whether the committee could levy fee under section 11(1) of the transactions affected by the appellant before they sold those goods to their customer. Agarwal's contention was that the fee levied under section 11(1) could only be in respect of goods bought and sold and not in respect of transactions where goods were only bought or only sold. According to him, it's only when a person bought goods and sold those identical goods within the notified area that a fee under section so-and-so could be levied. According to him, the transactions affected by the appellants consisted in their purchasing the said goods. They stopped at the stage of goods bought. Therefore, The other ingredient for the valid levy, the fee not being present. The fee levied in the present case was not in accordance with the requirement of section 11.1 and was unwarranted. This contention raises the question as to the meaning of the words bought and sold in section 11.1. At first sight, they appear to be susceptible to three meanings, namely, that they mean duality of transactions where the same person buys goods and sells those identical goods in the notified area. Two, that they mean bought or sold, the conjunctive and meaning in the context of subsection, the disjunctive or. And three, that they apply to a transaction of purchase, as the concept of purchase includes a corresponding sale. When a person buys an article from another person, the other person at the same time sells him that article, and it is in that sense that section 11 uses the word bought and sold. The incidence of the fee and the so-and-so is on the goods thus bought and sold. This last interpretation was favored by the High Court of Madras in so-and-so and accepted by the High Court in the present case. If the construction commended to us for acceptance by Mr. Agarwala were to be correct, namely, the appellant's transaction stopped at the stage of goods bought, there would not be a transaction in respect of goods bought and sold. If the fee was levied and sales effect by the appellant with a customer, its levy would not be valid in so and so, would also be referred to Article 286, where goods are delivered outside the state. With a well-settled rule of construction, the court should endeavor as far as possible to construe a statute in such a manner that the construction results in validity rather than invalidity and gives effect to the manifest intent of the legislature in enacting the statute. The object in passing the act was to prevent the mischief of exploitation of producers of commercial crops such as coconuts and copra, and to see that such producers got a fair price for their goods. The mischief to prevent with the act was enacted was the exploitation of producers by middlemen and those buying goods from them, and therefore the act provided facilities such as the marketplace, place for storage, correct payment, so the producers and the purchasers come face to face in a regulated and controlled market, and a fair price was obtained to them. If the construction suggested by Mr. Agrawala were to be accepted, and the section were to be construed as being applicable to those transactions only which have a dual aspect, that is, buying by a dealer from a producer and the dealer selling those identical goods within the notified area, the object of the act would be defeated. The larger number of cases transactions would fall at the stage of buying, and the committee in those cases would have no power to levy fee on them. Why is a buyer or a seller or a buyer and seller required to be registered, and why does the act prevent those who have not registered themselves from effecting transactions, commercial crops, unless the object was to regulate and control transactions in those commodities at all stages, and in a manner preventing the exploitation of the producer. I only substitute the words exploitation of public interest, disregard of public interest, closing your eyes to public interest. Therefore, they say much later the word bought and sold so and so aim at those transactions wherein the dealer buys from the producer who brings to the market his goods for sale. Transaction aim was viewed in the sense in which legislature intended to be viewed, that is, as one transaction resulting in buying on the one hand and selling on the other. Therefore, when it says sustained production in the middle, section 4b, it is one transaction, producing, removing, dispatching.
Yes.
Yeah. May I request your lordship now turn to page 9 of my written submission.
Yes. Yes.
Paragraph 24. How to connect the words mining operations occurring in section 4B and production and dispatch in section 4 capital A. While mining operations may carry a technical connotation of the activity of extraction of mineral, it relates to all classes of mining leaseholders. It is directed at ensuring that the mining is carried out in a sustained basis, namely optimal winning of quantum of mineral determined to be available. For instance, unlike oil and gas, there are so many uncertainties. Right? We don't have that here. Minerals like iron or coal are not one are extracted for use in themselves. Their regulated extraction is also not an end. Sustained mineral development thus carries the penumbral meaning of making available minerals for several end uses in order that the purpose of minerals extraction is realized. I place some emphasis on the use of the word penumbral meanings. Without contributing to such end-use availability, winning of minerals, namely production alone, is purposeless. Sustained flow of mineral wealth for end users is the essence of mining operations. Submitted that the express statutory mandate enacted in section 4B carries with it the penumbral meaning of all the other activities to give purpose and sense to it. It is not legislatively required to expressly state all its related set of activities to give its completeness. All those activities which can fall within the penumbra of mining operation ought to be legitimately read in as its connotations. The penumbra of meanings means matters not literally covered by the words or terms used in a provision. The law allows a penumbra to be embraced that goes beyond the outline of its object in order that the objects may be secured. Thank you, Michel. This is considered. I had the permission to place some dissenting judgments in some of the most important cases I've seen, and they become probably a majority view much later. Like, for instance, Justice Matthew Oily was judge in the Kerala High Court in Punan Thomas, state of Kerala, was talking about blacklisting, whether you should require a natural justice opportunity to be given to a person blacklisted. Much later, when he came to Supreme Court, minority view became the view in that. Therefore, sometimes the dissenting views are so powerful in their understanding and comprehension. So this is a case where there's a Holmes dissenting view. I'll read it for lordship can consideration. At running page 7 of the judgment. This is a case which concerns whether a gift which is made within a period of 6 years, which is the taxing starts days, if it must be in anticipation of your death. So if it is in anticipation of death, it can be taxed or not. So what exactly would that can be? Because Holmes has a slightly different view on this subject, whether it can have a strict reading or not. At page 7, Mr. Justice Holmes dissenting. You lordships have that? Page 7 of the judgment.
Yes, yes,
yes. If the 14th Amendment were now before us for the first time, I should think that it ought to be construed more narrowly than it has been construed in the past. But even now, it seems to be not too late to urge that in dealing with the state legislation upon matters of substantive law, we should avoid with great caution attempts to substitute our judgment for that body whose business it is in the first place with regard to questions of domestic policy that fairly are open to debate. The present seems to be one of those questions. I leave aside the broader issues that will be considered and take the statute as written, putting the tax on the ground of an absolute presumption that gifts of a material part of the donor's estate made within 6 years of his death were made in contemplation of death. If that time was 6 months into 6 years, I hardly it's in the power of the state to pass the law would be denied, as the difficulty of proof would warrant making the presumption absolute. And while I should not dream of asking where the line can be drawn, since the great body of the law consists in drawing such lines, yet when you realize that you are dealing with matters of degree, you must realize that a reasonable man may differ widely as to the place where the line should fall. I think the discussion should end if we admitted what I certainly believe, that reasonable men might regard 6 years as not too remote. Of course, many gifts will be hit by the tax that are made with no contemplation of death. But the law allows a penumbra to be embraced that goes beyond the outline of his object in order that the object may be secured. And repeat, the law allows a penumbra to be embraced that goes beyond the outline of its object in order that the object may be secured. So you can read the words sustained by mineral production in section 4b in a narrow way and says he's not able to achieve his object. But if you read the other way, then of course the penumbra part of it certainly comes. So I suppose in modern statutes, when we have to use several old, old English words where they have certain connotation, or words which have quite a certain meaning in trade and commerce or in usage, and you want to give a slightly different shift to the meaning. So therefore, we call sometimes and presently heard in discussions about language and how human mind is able to communicate this. So the potential linkages to a word or an expression is important. But in my understanding, the words production and linkage, production dispatch, were potential linkages to the whole expression of sustained mineral production. The potential linkages. Therefore, in section 4a, for a different purpose altogether, when I come to 4a, I'll talk about it, these potential linkages were expressly stated. Before the penumbra, a broader concept of an expression will carry penumbral idea, which will be linked to it, like a satellite. Therefore, you use the expression yesterday, the hub, and then you have the spikes of the wheel. So the spikes of the wheel of production, dispatch, removal, sharing, selling, all those things will be the spikes of the wheel. The hub is the production and sustained production. May invite Lord Chief to again one more judgment. Yeah.
Yes, sir.
We proceed further.
Yes.
This is a case where, for instance, kindly turn to the first page of the judgment. you have this whole. In India, we have this principle of illegally obtained evidence not being admissible. In America, it's a slightly different view. It's one of those cases in that context, whether use of evidence in a criminal trial in a federal court of an incriminating telephone conversation voluntarily conducted by the accused and secretly overheard, tapped by a government officer does not compel the accused to be a witness against himself. The majority held no, it is not so. And at page 17, just one observation made by Justice Holmes, which is part of a dissenting view by 4 honorable judges. Page 17, Mr. Justice Holmes.
Yes.
My brother Brandon has given this case so exhaustive an examination that he desires to add but a few words. While I do not deny it, I am not prepared to say that the penumbra of the 4th and 5th Amendments covers the defendant. Although I fully agree that courts are apt to err by sticking too closely to the words of a law where those words import a policy that goes beyond them. I suppose this is a wonderful proposition. So when you look at, you can have two lenses. One, a lens which will look at you very closely and said, stymie the meaning of a word, and therefore the word may not probably, the apt word to convey what the legislator intended to convey. Therefore it says sticking too closely to the words of a law, but those words import a policy that goes beyond. So the policy that goes beyond express words of Section 4B is the sustained development and systematic development of minerals, which are subject to a regulated framework. The Lord's permission, I'll hand over a copy of the judgment currently, and I'll just read it and hand over a copy. This is, again, very learned, yes, judges call learned hand, they call. What exactly would mean a sale, indirect or direct sale, etc. was the issue in this case. I read the last page of the judgment at page 5. May I, with a lot of permission, read. Compunctions about judicial legislation are right enough as long as we have any genuine doubt as to the breadth of the legislature's intent. And no doubt, the most important single factor in ascertaining its intent is the words it employs. But the colloquial words of a statute have not the fixed and artificial content of scientific symbols. They have a penumbra. They have a penumbra, a different a connotation for the express an attitude of will into which it is our duty, namely the duty of the court, to penetrate, and we must enforce ungrudgingly when we can ascertain it, regardless of imprecision in its expression. The copy. May read further at page now 10 of my written submission. As I said, paragraph 26, I've already talked about it, then paragraph 27. So on the contrary, section 4 capital A deals with specified class of mining leaseholders who may be treated as defaulters. In that context, sustained mining operation must be given precise and appropriate terms. In the absence of a provision of such precise terms of mining activity, namely quantum of production and consequential dispatch, a default position or condition cannot be visualized or considered, and the provision can be faulted for being vague. Further, minerals are not extracted for mere storing or showcasing. It is economic sin and against public interest that someone can be heard to say that production alone can be regulated and not the activity of orderly making available what is produced. A leaseholder cannot dictate to end user, the consumer, to wait for and abide by the dictates. It therefore conceptually and logically wrong to compare Section 4A with 4B, as if both provisions should have used similar expression, and that not expressly providing for production and dispatch in Section 4B rules out or negates any reference to orderly making available of extracted minerals. Plucking out such a purpose, giving activities from the legal and industry understanding behind the provision, is to deny due authority to the government to regulate the ABC of all mining operation and to assume to oneself powers and privileges beyond regulation, except the roles and works within the mining plan and the operational discretions to wisely and efficiently carry out mining operation. No leaseholder can arrogate to itself discretions not expressly granted. Further, to canvass the dispatch cannot be regulated or dealt with as a necessary concomitant of production is to argue in favor of hoarding mineral wealth at one's whim purely for self-determined profit ends. There is no room for any manner of hoarding of minerals once produced, nor that quantum of production and dispatch cannot be related to sustained mining operations or regulation. No such constitutional or legal right is available. Sustainable mineral development is a component of sustained mineral development. Sustainable mineral development is a component of sustained mineral development, but both have their respective spheres. Ensuring orderly and even flow of mineral wealth by requiring the regulated dispatch for end users is both sustained and sustainable development. Even if a hiatus can be suggested between them without conceding, it is for the government to pay attention. It's for the government to pay attention to it by laying such rules, regulations, or terms and amending them from time to time as the case may be. The petitioners canvass freedom from real public interest, which is the whole object of the Act, and hide behind profit motives, masquerading as public concern, allies unmanageable operational issues. Mineral development plans are only directional and guidance in technical and related aspects. They cannot be placed on a pedestal above statutory requirements or obligations. The tail cannot wag the dog. The authority to enact regarding orderly availability of mineral wealth for end users and to serve public interest can be exercised at any time it is perceived to be warranted and as and when warranted. Sections 4A, 4B, and Rule 12A are like three angles of a triangle integrally connected to the common purpose of sustained mining operation. Knock out one of them, and the triangle will be dead and collapse. The quantum of production achieved in a given mine by the previous lessee is a reasonable standard for continued mining operations on the same scale, except where it may be shown that the mineral estimates have been impacted or rendered unattainable. Those excusable circumstances are tolerable and condonable, but the possibility of such a circumstance cannot lead to the proposition that regulation, even if based on data knowledge about unstrained mining work or unregulated, non-supervised mining carried out in the past with no heed to user or industry requirement, coupled with illegal transmission, transportation will be illegal or excessive. Yeah. I therefore say that Section 4B is a cornerstone, and then it comes in a particular context, a historical context, and the future forward-looking purpose of this provision. So it's the cornerstone of laying the foundation for the regulatory framework. Can I now read? I've read para 24 onwards. I read. Can I invite Lord's attention to two paragraphs of the National Mineral Policy of 2019? I think it's available in this.
It's at the end of the bare act manual.
That is professional, madam? Is it?
What is the caption?
Mining and mineral development.
Development?
That's a heading of the paragraph.
Para 6 of the National
Mineral Policy 2019.
National Mineral Policy.
2019.
Yes. Paragraph.
Paragraph 6.
Yes. Last page 914.
My lords have that pen?
I have got. My brother is reaching.
That's all.
Nice.
It is 6 point. I'll read 6.1 and 6.2. It comes both under paragraph 6, mining and mineral development. 6.1, general strategy.
Yes, yes.
Minerals are a major resource for the core sectors of the economy. There is a huge demand for minerals in view of the rapid urbanization and the projected growth in the manufacturing sector. With a thrust on Make in India initiative, the demand for minerals is likely to grow at rapid pace. Extraction and management of minerals has to be guided by the long-term national goals and perspectives and integrated into the overall strategy of the country's economic development. How is there a magic wand by which you do all that? One magic wand probably is a regulatory framework. Therefore, how deep you will go into a regulatory framework and say, oh, this is too bad. So mining technology will be upgraded to ensure extraction and utilization of the entire run of mine. A thrust will be given to extraction of mineral resources in which the country is well endowed so that the needs of domestic industry are fully met, keeping in mind both present and future needs, while at the same time fulfilling the demand of external markets for such minerals so as to enhance domestic economic and social well-being. Then the primary minerals will remain the principal source of fulfilling demand. Efforts shall be made to augment supply by developing processes for recovery of metal through recycling. The reusable nature of the metals contributes to conservation of natural resources and includes other benefits in terms of energy conservation, so on and so on. Considering that a large number of merchant mining leases are going to expire in the year 2020 and for captive mines in 2030, effort shall be made to ensure uninterrupted supply of minerals over to the downstream industry. That's one of the major thrusts of the mineral policy. Therefore, to ensure uninterrupted supply of minerals. So, merger and acquisition, so on. So, paragraph 6.2. Conservation of minerals shall be construed not in the restrictive sense of abstinence from consumption or preservation for use in the distant future, but as a positive concept leading to augmentation of resource and reserve resource base. There shall be an adequate and effective legal and institutional framework promoting zero waste mining as the ultimate goal and a commitment, to prevent suboptimal and unscientific mining. So a suboptimal mining would be I'll mine the way I want, and I will not share the mineral wealth the way demand the industry required. The concept of collaborative mining amongst mining concessionaires located in so-and-so shall be encouraged to ensure optimum extraction of minerals. Value addition and general customization of product to be encouraged for providing fiscal and non-fiscal intervention. It is in this context that Regulation 12, Rule 12A came to be brought in the statute book and further amendments made in the year 2021. Yeah. May I now request the Lordship to turn to page 12 of my written submission. Page 12.
Yes, yes.
Yeah.
Paragraph 32.
I read, let me imagine, Rule 12A, minus 1A, 1B, 1C. So you have those new leases who come in 2020 who are asked for 2 years to produce the last production rate. And 2 says now for the future, you will draw a proper planning production for you so that there is a sustained production during the lifetime of the duration of the lease. Suppose we have only those two provisions. And with the absence of the penalty provisions in 1A, 1B, and 1C, will the provision really work and attain its effective object? For the penalty part of it came in as a necessary concomitant of ensuring that those sleepy mining operations don't sleep at all and have a regulation control over what they do. Therefore, 1A, 1B, and 1C for a different purpose came in later. So the entire corpus of 12A has to be seen from this purpose. The transition, old leases, 30, 50 years, and you must move toward an entirely different, vibrant way of working the minerals and the regulatory framework to ensure they work in a vibrant way. So 12A has that object. So you can't, as I said, pick up a small hole here and there and say, oh, this have been better, the rule have been framed differently. So let me read page 12, paragraph 32. Rule 12.1a provides for penalty for not meeting the requirement of minimum dispatch as specified in sub-rule 12.1. The rule provides for as to how penalty amount is to be calculated, which is based on the amount payable by the lessee under Rule 13 of the auction rules and auction premium, so on, etc. This amount is not the actual auction premium, DMF, NMEDT amount, which is payable on dispatch of mineral, but a penalty under Section 4B, read with Section 13.2AA and 13.2.1 of MCR 2016. Section 4B and 8B are not limited to 2 years after the amendment in the Act in 2021, which provided for vesting of all the clearances, approvals of the previous lessee and the new lessee, successful bidder, for the entire lease period of 50 years. You get a bonus on your hand. Now, 4B and 8B were inserted to maintain sustained production of mineral in the country. On the other hand, Section 5.2B mandates a duly approved mining plan before grant of mining lease. From the harmonious reading of Sections 4B and Section 5, new lessee is required to prepare a mining plan in such a manner that it meets the requirements of Section 4B, that is to maintain sustained production of minerals in the country. Rule 12A2 is unambiguous. 12A2 mandates two requirements, with the new lessee is required to fulfill beyond 2 years from the date of execution of lease. A, the annual production by the new lessee should be equal to or more than the annual production by the previous lessee. And the new lessee should work out and implement an annual production plan to ensure that mineral resources are fully exploited during the period of lease. Next page. There is no vagueness or conflict between these two requirements. The new lessee is required to meet both the requirements, that is, production should be more than the average annual production of the previous lessee in 2 immediately preceding years, and is also required to maintain such level of production that the entire mineral resources in the block is mined during the period of lease. I give you 2 examples. Situation 1. If remaining resources in the block after 2 years is 100 million tons, annual production of the previous lessee in the 2 immediately preceding years, let us say, is 10 million tons. Then, as per the first requirement, the lessee is required to maintain production limit of at least 10 million tons per annum. And as per the second requirement, the entire resource is to be exhausted within 48 years. In this case, if the lessee maintains at least 10 million tons per annum, the entire mineral resources would be exploited in 10 years. As such, the lessee complied with both the requirements. In situation 2, if the remaining resources in the block after 2 years is 500 million tons, annual production for the previous lessee in 2 immediately preceding years, let's say, is 8 million tons, then as per the first requirement, the lessee is required to maintain production limit of at least 8 million tons per annum. And as per the second requirement, the entire resource is to be exhausted within 48 years. In this case, the lessee has to maintain at least 10.42 million tons per annum, that is 500 years by so and so, to exploit the entire mineral resource in the remaining 48 years. As the lessee is required to maintain production of so and so to meet both the requirements. Therefore, there is no question of any vagueness is being argued on the other side. Next page. It therefore submitted Rule 12A2 is not vague or devoid of any details and provides clear guidelines for maintaining annual production to maintain sustained production of minerals in the country. The requirement of statutory dispatch for expired auction mines has been made in pursuance of Section 4B of the Act in the interest of maintaining sustained production of minerals in the country. Rule 12A was already in force, that is on 10th of March 2020, before the expiry of the previous mining lease, that's on 31st of March 2020, at the time of the auction of blocks. Therefore, the successful bidder were aware of the provisions of Rule 12A. The contention that the compulsory dispatch is manifestly arbitrary and perversely disproportionate is not correct, as the new lessee is required to maintain only 80% of annual production dispatch requirement and not 100% with the previous lessee was actually dispatching. The purpose of such compulsory dispatch was required in the interest of maintaining sustained production in the middle of the country as envisaged in Section 4B. The requirement of statutory dispatch for expired auction mines has been made in pursuant to Section 4B of the Act as a distinct category in the interest of maintaining sustained production of mineral country. Accordingly, under Section 8B, all valid clearances, approvals, and the like were transferred to the new lessee to ensure that there is no disruption in production and dispatch in the mineral in the country on account of non-availability of statutory clearances. Therefore, these leases are different and distinct from greenfield leases, which not only requires all the clearance, but also require time for development of mine and infrastructure before the start of mining activity. So you have everything on a platter. So for the Rule 12A also envisages the resources in the expired auction mine should be fully exploited during the lease period so that no further auction is required after the period of 50 years. I was telling yesterday, the paradigm shift is not looking at merely giving renewals and revivals and so on and so forth. You must be one which is fully in tune with the new paradigm shift in mining operation. Para 42, new lessee should work out and implement annual production, ensure this is fully exploited during the period of lease. Then para 43, and the heading Rule 12A does not create substantive obligation beyond those prescribed in Section 4B and 8B, and so on, and is not for ultra-virus. The principle contained in the words, in the interest of maintaining a sustained production of minerals in the country, constitutes the core element of departure from the pre-existing scheme of grant of mining leases and terms and conditions thereof, which were obtaining prior to the year 2015. Sustained production of minerals comprehends all those dimensions and aspects of regulated production of minerals in order that all possible industrial or other consumptions of minerals are assured continued availability of minerals. In order that there is sustained production of minerals, continuation of production followed by dispatch, both on a sustained basis, should also be ensured. The word sustained production of minerals connotes all these activities and operations which may fall within its penumbra in order that such integrally connected activities serve the public interest of the country. Section 4B, therefore, has been enacted to put in position a comprehensive scheme or regulation of mineral development from the stage of winning a mineral to the stage of due dispatch. In this view of the matter, the entire mining operations will have to be considered as a seamless set of operations, where in the absence of one set of operations, the other set of operations will not make full sense at all. Therefore, having regard to the public interest element which runs through the entirety of the corpus of provision contained enacted post 2015, will necessarily demand that mining operation will be given that comprehensive understanding. It may be seen that in order that those applicants obtain mining leases through the process of auction post 2015 must be enabled and facilitated to commence and continue mining operation, Section 8B has been enacted. It may be thus seen that as distinct from a pre-2015 regime of mining operation, which did not provide for adequate and comprehensive regulation, such operation in advancement of public interest, every provision enacted post-2015 are rooted in one purpose, namely that mining operation must meet without any disruption the needs and requirements of industry and the areas of social and economic development. In the above view of the matter, Section 4B cannot be read in any truncated manner, and which reading will defeat the purpose of the paradigm shift brought about under various provisions post 2015. Section 4B thus read connotes all those aspects, so on, etc. The details of how such sustained production of minerals can be realized will necessarily be a matter of delegated legislation. Rule 12A enacted in order that sustained production of minerals is guaranteed and secured provides in regard to the manner and method by which the purpose of Section 4B can be realized. If Section 4B cannot be given a dwarfed construction, Rule 12A also could not have been enacted without paying due attention to the object and purpose of Section 4B. In the absence of Sub-Rule 2 of Rule 12A, the question of securing sustained production of minerals during the lifetime of the lease will be in limbo. Sub-Rule 2 of Rule 12A has therefore been enacted to ensure that within the duration of the lease, when adequate annual production plan shall be put in position. An adequate annual production plan, which will convert well-organized production and dispatch, is the effective way towards maintaining sustained production of minerals in the country. Paragraph 50. In the hierarchy of the instruments of law, Section 4B stands on the top, ably aided by Rule 12A as a piece of delegated legislation. The MDPA is the next instrument of law, which is a necessary contractual framework towards securing conformity with Section 4B and Rule 12A. Next comes in the sequence the mining plan, which is only a matter of technical and all related operational guidelines. The submission that the mining plan exclusively governs the legal relations between the lessee and the government is misconceived. Having regard to the extensive requirement of managing and regulating the entirety of mining operation, it has been found necessary to have two heads of rule-making provisions, namely Sections 13 and 18. The several subject matters which are dealt with in Section 13 and 18 have to be read harmoniously and collectively towards securing the common object of sustained production of minerals in the country, and which sustained production must be duly informed by systematic development. The apportionment of matters between Section 13 and 18 does not mean there is a hiatus between the objects to be secured by these two provisions. The subject of regulation or the grant of mineral concession is closely related to the subject of systematic development of minerals. In other words, the apportionment of subject matter is only a matter of convenience and orderliness while permitting overlapping between them. It is therefore misconceived to contend the 2016 rules cannot enter in the domain of systematic development of minerals. It reiterated the dichotomy between regulation of grant of mineral concession and systematic development of minerals or sustained production of minerals is a false dichotomy. Consequently, Rule 12A, as part of the 2016 rules, traceable to the fundamental object of the law, public interest, can hardly be ultra-vires. May continue reading in the next page here.
Yes.
Now look at some of the consequences if Rule 12A is declared ultra-vires.
Converse impact.
That's right. The statement of objects and reasons, the 2020 amendment clearly highlights the need for insertion of Section 4B in the MMDR Act, empowering the central government to prescribe conditions for sustained production of minerals by the holders of mining leases who acquired rights under Section 8B as follows. The mining leases in respect of 334 mines of iron ore, manganese ore, and chromite ore expiring on 31st March 2020, out of which 46 are working non-captive mines. It's been observed that some of the states have initiated action to auction these blocks. However, the mines allocated to auction can start mining operations only after obtaining as many as 20 clearances from different government agencies. This process is causing inordinate delay in commencing of mining operation and subsequent production of minerals. That's why Section 8B came in. It was estimated that production of 60 million metric tons, or the total iron ore production of 206 million metric tons in 2018-19, is from the mines whose leases were expiring on 31st of March 2020. The other two important minerals, namely manganese and chromate, were also estimated by the impact at about 0.25 MMT out of 2.81 MMT and 1 so out of 3 so. The details are shown in the table below. So this is a public document, paragraph 55. To plan for the anticipated shortfall of iron ore production post 31/3/2020, it is imperative that the allotment and transfer of leases lapsing on so is facilitated seamlessly and in time. Under these circumstances, the provisions of Section 4B and Section 8B were inserted in the MMDR Act. It is clear that facilitation by transfer of all the clearances of previous lessee of expiring mine to the new successful bidder under Section 8B was made to maintain sustained production of minerals in the country. The phrase maintaining so and so has implicit reference to dispatch of minerals to make it available in the market. This entire aim was to prevent disruption in the market, which was expected to be caused due to expiry of large number of mining leases together and so on. So the purpose is maintaining in the country, that is to make the mineral available in the country. The provision Section 4B cannot be given narrow interpretive if the entire purpose amendments. If the rules provision is struck down, then it will bring back the position as it existed in the 2020 and render the entire exercise by the legislature and the union to ensure sustained supply of minerals in the country, and the purpose of bringing sections 4B and 8B completely negatory. It stated out of total 289 MT iron produced in so and so, 60 million metric tons of iron will be produced by such mine, and the rule is struck down. The same would have drastic impact in not just the steel industry, but the manufacturing sector. If we were talking about the impact. So this will further put strain on the economy, which is already going a difficult pace given the geopolitical issues, and lead to a chaotic situation for the entire manufacturing sector, and the country would suffer drastic consequences that would be unfathomable. For these mines were given all the clearances on a platter. Even these mining leases were executed within 15 days of the auction rules, whereas greenfield mine take up to 5 years for execution of mining lease and up to 3 further years to commence production and dispatch. And it is further stated that the petitioners were aware of all the conditions and the rule positions. Now they cannot turn back and argue. Rule is ultra virus providing for dispatch against the market forces. It is stated that these mines produce 60 million metric tons of iron ore, which comprises 25% of the total iron ore reserves of the country. Rule so and so shortfall would lead to inflationary situation and the cascading effect impacting the downstream industry. The impact rule so and so will not just be to the state of Orissa, but in the entire country. Because we have very many critical minerals in our country, but offshore mining, subject to several regulatory framework. The mobile we use, the battery, the quality of the battery depends on a very important mineral which adds to the magnetic quality of it. So they are all now available within the country. You won't have the sustained production available without disruption. So you have, you say Rule 12A because of iron and ore as a problem. We're not looking only iron and ore and steel. We are looking at the entire mineral wealth in the country. So 12A will be completely defeated and frustrated if then the delegated legislature to find out and sit back in the chair and say, which regulatory framework would probably a balanced regulatory framework? So should I yield to the market forces and say, or should I be on a higher level of asking the market forces to probably sustain within tolerable limits? So that's the whole question. For 12A is aim to achieve those objects. May I just quickly take losses to 4A for a minute, so that why we need to look at them in this context. Because as I said earlier, the subject and the thrust and the scope of sections 4B and 4A entirely different. We had the section 4A even earlier, and what were brought in by the amendments in 28th of March 2021 was substitution of the words in the words mining operation, production, dispatch. So kindly read with me. Allow me to read section 4, capital A. Let me read the entirety of it. Where the central government, after consultation with the state government, is of opinion that it is expedient in the interest of regulation of mines and mineral development, preservation of natural environment, control of floods, prevention of pollution, and all that, right? Ensure safety of buildings, monuments, structures, conservation of mineral resources, of maintaining safety, or for such other purposes as the central government may deem fit, may request the state government to make a premature termination for prospecting license or exploration license or mining lease in respect of any mineral. Can somebody be heard to say that any one of the heads of subject matter or way where termination could not have happened? And let me read further how could I make the submission. The state government shall make an order making a premature termination of the prospecting license or mining lease with respect to the area or any part thereof. So that's where the central government comes in, and where the state government is opinion expedient the interest of regulation of mines and mineral development, preservation of all that is repeated here, and then the state government may deem fit, respect so and so, make a premature termination. And then comes subsection 4, where the holder of a mining lease fails to undertake. Let's say I don't look at the words production and dispatch. I only say fails to undertake mining operation, continue to be under statute. So if the words production dispatch are not brought in here, so if according to them, dispatch could never be in part of mining operations. I'm going to terminate your lease. You will come and say, how are you terminating my lease? You not told me that I'm not dispatching. You not told me that I have produced and not dispatching. So in order that the termination part of it assumes some certain clarity and position, the words production dispatch, which are subsumed with the meaning of mineral operations, have been brought in expressly only for the purpose of ensuring nobody can complain on the basis of vagueness. Therefore, 4A operates in an entirely different context altogether. So therefore say, oh, you found.
According to you, this amendment is merely a clarificatory in nature.
That's right.
Not really substituting or supplanting something
Absolutely.
that was already there.
Absolutely. And therefore, such clarification for a particular purpose and the context, you can't say, oh, you have not implanted this clarification in section 4B, and you can't read section 4B so widely to probably connote all these production dispatch at all. Therefore, this operates for a particular context, so clarification in nature, and that's how probably one should look at section 4A. I don't think we need to supply judgments on how clarifications, have prospective, retrospective, or wide application, etc. Now, I was reading page 20 of my original submission. Paragraph 63. It is submitted that a mining plan is an operational and technical instrument intended to give effect to statutory and contractual obligations. It being a condition precedent for signing of the mining lease, cannot override, amend, or prevail over the binding terms and conditions of the Mineral Development Production Agreement executed under the MMDR Act. A mine development and production agreement is a statutory agreement flowing from a conjoint reading of section 10A and 11 so and so, read with sections 18 and all that. I'll fill up that gap. Sorry for that. The Mineral Auction Rule 2015, there's the Mineral Concession Rule 2016, there's the tender document and the final bid document. I'll read each one of them presently. There's once executed, it becomes the primary source of rights and obligations governing the parties. It's humbly submitted that the mining plan is a technical document and is prepared by a lessee and approved by the Indian Bureau of Mines. Further stated, the mining plan is amenable to be revised or modified under Rule 17 of the MCDR 2017 and it does not create financial or performance obligation. On the other hand, the MDPA is a statutory contract and must be complied within letter and spirit. Also essential to note here that MDPA requires compliance with a mining plan as well as the provisions of the Mineral Concession 2016, which have in fact been incorporated in the body of the contract itself. Thus, the petitioners having first entered into an agreement to comply with the condition date and so cannot be now challenged the law only because it is commercially unsuitable for the petitioners. I say though it is not so demonstrated. Now, let me continue reading paragraph 68. The purposive construction of statutes is now well settled. Between two suggested alternate readings of a word or a provision of a statute, that reading which will advance the object and purpose of the law will be preferred. The Mineral Law Amendment Act 2020 follows the understanding in regard to obtaining sustained development of minerals following the paradigm shift from grant of mining leases on the base of application to grant on the base of auction. The auction tool has been conceived as a transparent, facilitative tool which will accommodate both competition and regulation. 2020 Act has been designed to achieve the above said two objects. Sections 4B and 8B in the Company of AT are meant to provide the necessary authority of law to enable the quick transition from unregulated or inadequately regulated mining domain into a properly and duly regulated domain. These provisions are meant to be a permanent part of the MMDR Act in order that all current or future mining operations will always fulfill national and public interest. They were not enacted as a mere temporary or a transient provision to live only during the period stated in Section 1.3 of the Amendment Act in 2020. An argument is drawn for 6 years of life during which 4B and 8B would be there, thereafter they will die. I think the argument I'll come to it presently. So subsection 3 of Section 1 is a unique provision. Before I go to it, you ordinarily probably Section 6.3 is enacted at a time. You have a parent act and an amending act, and there is some time before a repealing act comes. So therefore it says in operation, we use the word in operation. Here where subsection 3 of Section 1 contains all of them. The entire act contains an amending act and also a repealing provision. It's a very unique provision. Subsection 3 of Section 1 is a unique provision which provides for a duration of 60 days from the date of assent by the President, and the period during which the Act of 2020 shall remain in force. This does not and cannot be taken to mean that the entire Amendment Act of 2020 will also remain in force only during the period of 60 days and will die thereafter. Parliament did not bring about a temporary legislation in 2020 and then not being able to achieve the entire purpose of shifting the whole paradigm shift as I talked about. And such a construction is opposed to all canons of interpretation. It is well settled that once an amendment is brought about by an amending act, the amendments shall be taken to become part of the parent act. After they become such a part of the parent act, the need for retention of the amending act on the statute book will cease to exist. That this being the state of law, any contrary reading of the amending act, particularly subsection 3 of section 1 or so and so, will be entirely misconceived. I'll just presently read those observations in two judgments, 54 Calcutta and then Supreme Court in 1960. The words, it shall remain, the words, it shall remain in force for a period of 60 days from the date of assent by the President and shall be deemed to have been repealed after the expiry of the said period are mere surplusage and cannot be the governing part of the amending act. Even in the absence of these words, the legal position will still remain the same, namely, provisions sought to be brought into the parent act will become part of the parent act. When the purpose of integrating the parent act, the amending act is done, the need for the amending act to remain in the statute book will make no sense. In this view of the matter, Section 60 General Clause Act will also have to be read accordingly. In the absence of the provisions contained in Section 8B, these new leaseholders who come into the picture post 2015 will be bereft of the facilitating scheme of continuation of approvals and clearances, without the need for the new lessees to invest their time and resources towards securing clearance and approvals, which in the normal course will consume considerable time. This facilitating provision is an integral part of Section 4B. Those who are facilitated by Section 8B are necessarily called upon to abide by the regulatory framework conceived under Section 4B. In the absence of these provisions and the rules made thereunder, it's hardly conceivable that the systematic development of minerals in the service of public interest can be duly secured. Therefore, submitted that having regard to the settled law and section so and so, no purpose would be served by entering into any lexicographic analysis of subsection 3 of section 1 of the 2020 Act. Finally, post 2015, large number of existing mining leases will expire by the year 2020. In respect of all those mining leases, mining plans contained inter alia stipulations regarding authorized annual quantity of mining. In the tender document inviting tenders for grant of mining leases in the year 2019, but at 10.3 thereof expressly stipulated therein. May I take your lordships to, let's say, in petition? Okay, petition. May I request your lordship to pick up this RAMAN, petition number 5215 of 2025.
You have quoted in the next page. You have extracted that particular clause
I will try.
in the
I
next
thought there are more things to be read, therefore I may
Yes.
take a lordship to
page
the paper book. Kindly turn to page 70 of this paper book.
70.
Yes,
Yes.
16.
We have series of documents here. First is the tender document.
Yes.
The tender document begins at page 49. That's where everything is set in motion. And we go to page 69, paragraph 10 of the tender document. At the bottom of that page, paragraph 10.
Yes, the preferred bidder.
Declaration of successful bidder. That's how the paragraph begins. Para 10. You also have that page?
Yes.
Yes, at the bottom of page 10.3. Execution of mine development and production agreement. The state government and successful bidder shall enter into the MDPA upon the successful bidder having obtained all consents, approvals, permits, objections, so and so, and the applicable law for commencement of mining operation. The preferred bidder, successful bidder, shall not. You can skip clause A and B. What you will do? We shall not seek approval for a mining plan for production of quantity of mineral which is less than the authorized annual quantity in the mining plan valid as on date of expiry of the mine lease currently granted in respect of mineral blocks. So you enter into a tender process by this is the first step. If you are bound by it, you will not ask for anything else other than this. Now kindly turn to page 140. In fact, along with the tender document, the entire format of MDPA is set out. Kindly turn to page 140. Which is again repeated here. The same condition will probably figure later when you actually sign the MDP. So page 140, Schedule D, minimum production requirement. Successful bidder shall meet the annual minimum production requirement as stated in the table below. First year, second year, third year, shall have 80%, all that is stated there. Then next below that, the preferred bidder, successful bidder shall not have. Earlier it says shall not seek, now it says shall not have. So when you enter the agreement stage, you will give up all those things. So shall not have sought approval for a mining plan, which is just a reproduction of what I read at page 70. Now kindly turn to a few more pages. One minute. One. At page 170, some of those definitions I would like to probably read for Lordship's kind. The MDP which came to be signed, the mining plan is defined at page 169, clause 1.1.22. Mining plan means a mining plan drawn in accordance with clause B of subsection 2 of section so and so. The case may be by a previous lessee in accordance with section 8B of the Red Act, with so and so, and mineral rule 9A and all that rules. Now kindly turn to interpretation, the next page, where clause 1.2.1. Any reference to any statute or statutory provision should include all subordinate legislation made from time to time under that provision, whether or not amended, modified, reenacted, or consolidated. And such as from time to time amended, modified, reenacted, or consolidated to the extent amendment, modification applies to, or is capable of applying to any transaction entered into and the agreement prior to the agreement date will include so and so. Therefore, a very flexible framework is conceived here. Kindly now turn to page 196. That's where we have 12A, which is finds the position. This is even though after schedules A, B, and C, this is schedule D. The top, though it is not there, it is schedule D. So schedule D, in fact, extracts and inserts 12A. Rule 12A is part of this agreement. It's a format. So it is not that Rule 12A took you by a surprise later. Now, a few more documents. At page 197, there are several warranties. Schedule E. Then we have para 2 and para 3 in the next page, general. At the bottom of that page, clause 3, para 3, clause J at the bottom of page 198. Are just without prejudice to any express provision contained in this agreement, the successful bidder acknowledges that prior to the execution of the agreement, the successful bidder has, after a complete and a careful examination, made an independent evaluation of the lease area and information provided by the state government and determined to its satisfaction the nature and extent of the risk and hazard that are likely to arise with so-and-so in the course of performance of the obligation. Also acknowledges and hereby accepts risk of inadequacy, mistake or error in relating to any other matter set forth above, to confirm state government, any government authority shall not be liable so-and-so, which means one of the very well-known warranties. So I have done due diligence. Then kindly turn over to page 206, which is the lease, mining lease. And so it begins at page 205, the mining lease deed. So electronic auction, etc. Paragraph 2 of this grant of lease at page 206, 2.4. The maximum annual production under approved scheme of mining plan is so and so, so and so. Provided that in case the lessee desires to enhance the annual production, limited the production limit after revising the scheme of mining and obtaining the requisite statutory clearances, he shall execute an amendment to the lease before enhancing the annual production beyond the aforementioned limit. Therefore, there's no restraint on enhancing the production. Suppose the mining lease or the MDPS had said, you will only produce the minimal requirement. And you will come and say, look here, what's the potential? Why can't I do more? How are you restraining me? Therefore, but when you have to go along with an enhanced production, you will still have to inform me. And what is the production requirement? You will produce and therefore obviously dispatch to the market. Then 3.1. The rights and obligations of the state government and the lessee shall be as specified in the Act and the rules made thereunder, including without limitation the minerals other than so-and-so mineral considered 2016 and the mine development and production agreement dated 27/6/2020. So there is a very clear express incorporation of all this in the mining lease. Now, a few more reiterating parts of it at page 219 and 219, when the letter of intent was issued by the government of Orissa, which is prior in point of time to this mining lease, which is a letter of intent of 18th of March 2020. Kindly please read at page 220, paragraph 3.1. This letter of intent and subsequent grant of aforementioned mining lease shall be subject to the provisions of the Act and the rules made thereunder, as amended from time to time. And the Naveram Power and so-and-so shall be designated the successful bidder and subsequently granted the mining lease only upon satisfactory completion of all the requirements so-and-so. State government may impose such other conditions in the mine development production agreement and or mining lease as will be considered by the state government to be the interest of mineral development and in public interest. So following the letter of interest, you sign the mining lease. And at 221, we have another 221. I read out at page 70 and 140 those conditions in the tender document. So 221B, paragraph B, below that,
Intent.
so the signing of the mine development and production agreement, and that 1A, the preferred bidder. The preferred bidder, under paragraph B, below that,
Yes,
we have
yes,
subpara 1 and then clause
Roman
A, B. B
Roman
is the,
1.
Your Lordship, please.
Roman 1.
That's right. Under that, we have clauses A, B. Clause B, subclause B, is what I read out at page 70 and then 140, etc. The same thing.
Yes.
You will not seek approval for a mining plan production of quantity less than the authorized minimal quantity. So the authorized minimal quantity in the mining plan obtaining at the time you came into the picture will bind you. Therefore, Rule 12 is only talking about that. And then in order that 4B purpose is advanced, Rule 12 says, over a period of time, what will you do? You will have a sustained mineral development. And what does it mean? Development, production, and dispatch. Therefore, to bring artificial division between this series of activities and say one can be regulated, other cannot be, which means that you defeat the entire purpose of Section 4B. And that's why you come and say Rule 12 is bad. It binds my hands. It doesn't allow me a free key to move wherever I want to go. And page 222, at the bottom, at the top of the page, again, the first paragraph, immediately preceding 2 years, and this will be incorporated in the MDPA as the minimum production requirements. And that there is a failure, provided further, in case of failure to comply with this requirement, without prejudice to any other rights available to it under applicable laws and MDPA, including the recovery of so-and-so, the lease may be debarred from participating in the future auction of minerals so-and-so, so-and-so. Can give it. Fruits of a legal matter from this purpose of connecting it will be available. Well, I cited few judgments on the penumbra concept. I thought some of those few good articles which look at the history of it, and particularly in the US constitutional history, we have borrowed it only mostly in the context of rights. So that the right to privacy, Article 21 is all exposition all about penumbras. But I was asking myself a question: why, even a statutory context, a penumbral idea cannot be even in? It can be. It all depends. That's why it's another limb of purposive construction. If something could have been stated more expressly, then the legislature probably has not done it so. Does it mean that legislature never intended to do so? May I just seek Lordships to a few permit me, I'll go through them. Anyway. Those two judgments under Section 6A, I'll currently get them and probably refer to them a little later. If you Lordships pick up this statutory interpretation, core meaning and marginal uncertainty article first. This article deals with a very interesting discussion between Hart, the famous jurisprudent, English jurisprudent, and Fuller and Hart. And but more importantly for our purposes, how kindly just look at the third paragraph in this page 1 of the article. On the other hand, or second paragraph, that the warping has been partial is witnessed by the presence in almost every discussion of statutory interpretation of an express or implied, though sometimes grudging admission that despite the vicissitudes of ambiguity, overvagueness, and overgenerality, most language is clear in at least some of its applications. Beyond the general perfunctory recognition, however, little direction has been given to the areas of clear meaning, mainly because the legislative squeak that gets the judicial oil. So I only say that section 4b in the legislative squeak but get the necessary judicial oil. Now, on the other hand, the full-blown theory of interpretation of statutes, even though preoccupied with resolving significant uncertainties of meaning, cannot deal adequately with uncertainty without taking into account or the basis for certainty in meaning and the bearing that the certain has on the uncertain. Except for an utterance composed wholly of gibberish, the character of a specified uncertainty of meaning is shaped, at least in part, by the relevant certainties. Thus, an ambiguity presupposes at least two particular alternatives, each of which, taken alone, is free of ambiguity and not so vague as to be meaningless. And similarly, a margin of vagueness presupposes a non-marginal area that is free of ambiguity is clear because it is by hypothesis non-vague. That's what just Holmes was talking about. It may not go beyond the object the law says achieve. And at the bottom of that page, there's one of the famous illustration given by Hart in his article. He wrote an article on discretion, which was published after he went to US. At the bottom of that page, on core meaning, Hart supposes a situation. A legal rule forbids you to take a vehicle into the public park. Plainly, this forbids an automobile. But what about bicycles, roller skates, toy automobiles, and what about airplanes? So both Hart and Fuller talk about whether Hart is correct in giving a particular way of looking at it. Therefore, vehicles is a word of broad term, like the word political. Political probably you can only brought in certain very, straitjacket formula. For a large number of expressions, ideas, and principles, which are sought to be conveyed through the vehicle of language, which sometimes will be inadequate in what it intends to convey. Therefore, the court will try to lean forward in finding out whether this is the meaning or the intent with the legislature intend to convey. Therefore, we look at vehicles here mean many things. So kindly then turn to the third or the fourth page. Of course, in the third page, which is a well-known talk about purposive construction, there is an extract from, let's at the bottom of the page. Page 3, there's an extract. We do not proceed simply by placing the word in some general context. Rather, we ask ourselves, what can this rule be for? What evil does it seek to avert? Surely, the judicial process is something more than a mere cataloging procedure. And then in the next page of this article, the bottom of that, a reference to a book on language, thought, and reality, last paragraph. To this last question, and just why are they asking this? The paragraph above it. Such an assurance invites this question, by what means is the legislative purpose so obviously manifested? Is Fuller the one certainty as to purpose unrelated to an element of certainty in the individual words of statute? Or the words of a statute devoid of content when uttered out of context? To the last question, Oakes believe that dictionary meanings derive from the patterned potentials of linkage seems pertinent. I look at the patterned linkages between sustained mineral production, and I said production, dispatch, removal, they're all potential linkages, the whole idea of sustained mineral production. And therefore that will be pertinent. I don't propose to trouble you lordships much in reading this, except at page 6 again. The paragraph beginning, third kind of specific, you say that colors or supplements, meaning include the relevant assumption that are left tacit because by usage they are not only agreed on, but be taken for granted. Perhaps the simplest example is the one suggested by so-and-so, and the writer of a document dates it at 1/4/64, intending to refer to January 4, 1964, rather than April 1, 1964, is tacitly assuming that his addressee, like himself, is operating under the usual American, rather than the British or military system of indicating dates. In general, tacit legislative assumptions or established usages common to the legislator and the legislative or even to the particular statute. The Lordship can now pick up the other one, penumbra, the roots of a legal metaphor. But before going further, right, and I was beginning to reflect on this, how do you, if there is a genuine concern about the Section 4B failed to convey the intent behind what the Parliament really intended to do, and if it has failed to convey, and therefore it will be read in a very narrow, restrictive meaning, now would it serve the purpose? Whose purpose would it serve? So I tried to reflect on that and to find out if whether we look at it from a very broader angle. We're looking at a very important statute for our country. There are several statutes today in modern social and economic development which must necessarily receive very broader purposive interpretation. In that context, I thought, why not we look at it from the angle when we talk about penumbral rights in the Constitution, why can't they also be extended to statutory considerations? I did not find anything is probably coming in the way of extending this analogy to statutory constructions and statutory constructions. Therefore, Section 4B, in having regard to the purpose of the Act, must necessarily receive a penumbral area where all those activities which will form part of a mining operation, sustained mining operation, will have to necessarily receive. That's why I looked at some of the articles and thought we would throw some light on how we look at some of them. Can you turn to page, this doesn't have a running page. At the top of this article, page 84, it was a very interesting really to find out written how several state Supreme Courts and district courts and US Supreme Court has used this word penumbra from over point of time. Sometimes it's different distinct meanings. And though in Griswold, the court said privacy right would be brought within the penumbra of the due process of law. At the top of the page, extensive research suggests that the 1873 statement of Holmes is the first time the penumbra metaphor appears in American jurisprudence. Holmes seems to use the word penumbra in its primary meaning, a space of partial illumination, as in an eclipse between the perfect shadow on all sides and the full light. The penumbra, he suggests, is a gray area where logic and principles falter. Holmes asserts, however, that lines should be drawn, even though they are to some degree arbitrary and philosophical. Judges should press on in spite of reason's limits, perhaps because of them. Flanked by polar principle with cases clustering on one side, Holmes' common law judge draws a line through the area of partial illumination. Then Holmes, this line drawing may even end uncertainty and thereby banish the penumbra, at least until the common law again needs to grow. Perhaps this extract is interesting. Perhaps the reasoning of the case has not always been as sound as the instinct which directed the decisions. It may be that sometimes it would have been as well not attempt to make out the judgment of the court as consistent with constitutional rules, if such rules were to be taken to have the exactness of mathematics. It may be that it would have been better to say definitely that constitutional rules like those of the common law end in a penumbra where legislature has a certain freedom in fixing the line as has been recognized with regard to the police power. Then Holmes clarified the penumbral uncertainty as a grant of freedom to the decision maker and all that. Kindly, I read the other judgment on Schlesinger, Wisconsin. Kindly turn to page 86 of the article. This part of at Homestead, no? Homestead. Yes. They extract at the bottom of page 86 from the judgment which I read out. Let's kindly turn to page 89, this article. The reference to number of judges, including Judge Learned Hand. Page 89, para D, Judge Learned Hand. Compunctions about judicial legislation are pitched right enough as long as we have any genuine doubt at the breadth of the legislational intent. No doubt, the most important single factor in ascertaining this intent is the words it employs. Either the colloquial words of a statute have no fixed and artificial content, a penumbra, a difference, a connotation, but they express an attitude or will into which our duty to penetrate and enforce ungrudgingly, then we can ascertain regardless of the imprecision in its expression. Then that graphically employs Holmes' penumbra to statutory force. Statutory language, like all language one suspects, has a different connotation. But Hans says that the judge cannot treat the statutory uncertainty as a grant of unbridled discretion. In Hans' view, the penumbra of a statute is seen as words radiating will, which judges have a duty to penetrate and to enforce. The phrase clear and present danger has come to be used as a short-term statement of those among such mixed or compound utterances. It's not a vademecum, but very words it could not be. It's a way to describe the penumbra of occasion, even the outskirts of which are indefinable, but within which is often the case, the courts must find their way as they can. In the next article, the first page, the Lordships permit them, I'll continue after lunch so that I'll cite 3 more judgments. Sorry for detaining.
Item 15, my lord, interim order may be extended, my lord. Item 15, my lord, interim order may be extended.
Let us see, we are sitting at 2. Don't we?
Item 4.
Yes.
I was in the third article that a footnote to Penumbra, Griswold versus Connecticut. Let me read a few pages of this. They make good reading. First page, the paragraph begins like this.
Of?
This is a footnote to Penumbra, Griswold versus Connecticut.
Yes.
So since Justice Douglas' opinion for the court in Griswold, the source of the federal constitution right to privacy in is also. A penumbra seems a strange place to find rights to use contraception.
Page.
First page.
First paragraph.
At the bottom of your page 251,
Yes.
first page. Penumbra seems a strange place to find rights to use contraception, to own obscene literature, to own abortion. Penumbra is an obscure word known to few. If the reader knows its meaning, it calls to mind shadows and darkness and unfortunate connotations for affirmative rights. Then why did next paragraph? Why did use penumbra describe the source for a privacy right? Did not appear in the briefs in Griswold of the lower court decision, not used in the academic commentary, not been featured in earlier opinions. Is explore that a question through an examiner the history of the judicial use of penumbra before Griswold. Something very interesting here. Astronomer Johannes Kepler coined the word penumbra in 1604 from Latin word spene, meaning almost, and umbra or shadow. Kepler was describing eclipses and invented penumbra to distinguish between a sharp, deep shadow or umbra of Earth, and so on so. During a full lunar eclipse, and the less distinct shadowing that surround the umbra and produce a partial lunar. This technically meaning is still the primary meaning of the word, but in the last 300 years, 85 years, penumbra has acquired other meanings, including two other technical definitions. In astronomy, the lighter portion, the periphery of the sunspot, and in art, the art of painting where shadow fades into light. It's also acquired figurative sense relevant to the inquiry. Oxford English Dictionary uses metaphorical use of penumbra back at least as far as 1801, when a female English novelist, not an aptly Jane Austen, wrote, "I will defend you, madam, against every shadow, every penumbra of aristocratic insolence." Now kindly turn to the fourth, that is, at the top you have the page number, page 254. Again, there's a reference to Justice Holmes' usage of this, the whole history of how he has been using it. At page 253 bottom, between 1899 so-and-so, Holmes used penumbra in 3 decisions of the Massachusetts Supreme Judicial Court, most significantly in so-and-so. In Danforth, the plaintiff's eminent domain case against the water company had become entangled in shifting procedural statute that was barred, then allowed the plaintiff's recovery. Holmes referred to penumbra in discussing the nature of constitutional rules. Perhaps the reasoning of the case has always not sound, or the instinct which directed the decision. It may be that sometimes it would have been as well not to attempt to make out the judgment of the court was consistent with constitutional rules, if such rules were to be taken to the exactness of so and so. Better to say definitely constitutional rules like those of common law, Indian and penumbra, where the legislature has a certain freedom in fixing the line, has been recognized with regard to police power. Now turn to the next one page, page 255. Holmes first used penumbra in the Supreme Court in so-and-so. At issue was the geographical reach of the firm's common law mark, tea rose flower. Holmes concurred but suggested that state borders would provide a useful limit to the trademark. If this view would be adopted, we get rid of all questions of penumbra, of shadowy marches difficult to decide as the business extends to them. We have sharp lines drawn upon the fundamental consideration of jurisdiction originating the right. Then at the bottom of that page, last line, Holmes maintains that federal court should not admit wiretap evidence. I read out that earlier. Now kindly turn to page 256, the second paragraph at page 256. The reference is now to just learned hand. And used penumbra in 11 opinions from so-and-so. Although the context in which he used penumbra varied, he generally used to denote the indistinct borders of words or concepts Holmes had usually used penumbra when he was trying to stress the need to draw an appropriate line, if the line itself would be inevitably be arbitrary. A line between juvenile and adult, between day and night, between constitutional and unconstitutional assertions of power. And use it when he wanted to assess the difficulty of defining words or concepts as used in statutes, contracts, trademarks, or ideas. I think that's where I stand. Hand first used the penumbra in Lambert so-and-so, and the trademark is cited 1 year before Holmes' concurrence in Hanover. The makers of Listerine sought an injunction against the manufacturer of similar disinfectant named Listogen. The defendant claimed that it was not aping Listerine, which had been distributed under the name for 34 years, but referring back directly to Lord Lister, the promoter of the antiseptic principles. It cited the words Listerism, Listerian, and Listericides, which it claimed had been used in English before the distribution of Listerine. Hand rejected the defendant's argument, and he says, but the defendant does not use these words. At best, Listogen is a coined word with a penumbra of suggestions. When you talk of sustained mineral production, it's a word coined for the purpose of advancing the object of this law with a penumbra of suggestion, namely production, disguise, removal, and all that would constitute that. There were several suggestions which are incorporated. The next, in Poznan, Hand is construing a clause in a shipping contract concerning other circumstances, which are likely to give rise to delay, difficulty, discharge included. The clause merely added a penumbra of meaning to each of the specific terms, so as to include similar things not literally covered by the terms themselves. So, in van so-and-so, you considered whether a manager was a mechanic, working man, or a laborer for purpose of statute giving divisions of employees, the preference receiverships, and the word employee in defined so-and-so as mechanic so-and-so. But these three words are plain enough, and that remains no penumbra. Therefore, whereas there is no uncertainty, you don't have to go for that. I mean, just leave it at that, and then just one judgment which I need to read, that I refer to section 6A, the Supreme Court judgment in Jetana, which incorporates a very useful proposition of law by the Calcutta High Court. Paragraph 2 of this judgment. Jetanan, the appellant agent, was prosecuted along with another in the Court of Magistrate First Class under Section 6(1)A of the Act for possessing a wireless transmitter in contravention of the provisions of Section 3 for the Indian Wireless Telegraph Act, under sentence 6 years, 6 months rigorous imprisonment. Appeal so-and-so upheld the conviction, reduced the sentence. Then on revision, High Court confirmed both the conviction and the sentence. An application court did the same but limited the question of sentence. Learned counsel raised before the following contentions. Section 6(1)A of the Act was repealed, and therefore neither the conviction nor the sentence thereunder could be sustained. And 2, if Section 6(1)A of the Act was repealed, this court, in limiting the appeal to the question of sentence, only went wrong, for if that section was not in the statute book at the time of the alleged commission of the offense, not only the sentence but also the conviction thereunder would be bad. Both the contentions raised turn upon the same point. The different steps in the argument we stated thus. Act 17 is originally stood there was no specific provision making the possession of wireless transmitter an offense. So for our purposes, there was nothing like production and dispatch earlier. But the Indian wireless telegraphy, in after called so-and-so, Section 6(1)A was inserted in the Act, where under the possession of a wireless transmitter was constituted a separate offense. The amending act was repealed by the Repealing and Amending Acts also called, with the result that in the date of the alleged commission of the offense, the said section was not on the statute book. If that was the legal position, the limitation on the leave granted this court would result in an anomaly, namely that the conviction would stand but the sentence would be quashed. The argument so presented appears to be plausible, but in our view, not sound. Then I'll take your lordships to paragraph 6 of this judgment. The general object of the Repealing and Amending Act is stated in Halsbury's Laws of England. The Statute Law Revision Act does not alter the law, but simply strikes out certain amendments which have become unnecessary it invariably contains elaborate provisos. In Kurabaks versus so-and-so, Chakravarti's Chief Justice neatly brings out the purpose and scope of such acts. The learned Chief Justice says at page so-and-so, such acts have no legislative effect, but are designed for editorial revision, being intended only to excise that matter from the statute book and to reduce its volume. Mostly, they expurgate amending acts because having imparted the amendments to the main acts, those acts have served their purpose and have no further reason for their existence. At times, inconsistencies are also removed by repealing and amending acts. I stop here for a minute. So if the 6 months period was not enacted in subsection 3 of section 1 of the 2020 Act, and that came much later. So subsection 3, all that say during the 6 months period, the amending act will also be alive for the parliament to revisit that legislation. So that period, the parliament can come back and say, I'm going to put my hands once again into it. But once it becomes imparted part of the parent act and 6 months gets over, parliament does not, evince an intention to revisit during that 6 months period. So therefore, I continue further. At times, incons also, the only object of such acts, which in England are called the Statute Law Revision Act, is legislative spring cleaning, and they are not intended to make any change in the law. Even so, they are guarded by saving clauses drawn with elaborate care. It's therefore clear, main objective was only to strike out the unnecessary acts and excise that matter from the statute book in order to lighten the burden of ever-increasing spate of legislation and to remove confusion from the public mind. The object of the repealing and amending act was only to expurgate the amending act of so-and-so along a similar act, which has served its purpose. Now, it's a common phenomenon today. We have from time to time large number of repealing acts are brought to the statute. Therefore, this is how the law should look at section 6A, and it is not that Parliament intended to create, as I said, enact a temporary legislation by inserting important provisions brought about fundamental changes in the entire 1957 Act. 4B and 8B as fundamental changes. Therefore, Parliament could have never intended to say, I bring in a temporary legislation and they will die after 6 months. Therefore, the Rule 12A was enacted after the 6 months. Therefore, it could have never been enacted at all. Now, I want to place and record as I said, the direction in which the nation is moving. We have a 2025 copy of that.
Amendment Act.
There is a further 2025 Amendment Act, which shows in what direction are we moving. I'll just read out a few provisions. For instance, the captive, as far as the captive mine holders are concerned, and they had certain restrictions on what they can do, sell, or transfer earlier. Kindly turn to 2 or 3 important developments that are taking place under this. At page 2 of this, I think it's like the Agriculture Marketing Act, which brought in a place where the market area, the producer and the seller can come together so that the middleman can be avoided on all that. Now we're moving towards a very important development here, clause AF at the top of that page. The Parliament now envisions this. Mineral exchange means an electronic trading platform, a marketplace register, in accordance with the provisions of the Act, where buyers and sellers of minerals, its concentrate, or its process forms, transfer, trade, and enter into a contract including derivatives. So once this Act comes into force and this mineral exchange platform is brought into force, will you still say, oh, dispatch is not part of a contract? Dispatch is not part of any process of mining of minerals. So that's soon going to happen. Then the further facility given by this legislation, section 4, in the Principal Act, in section 8, capital A, in subsection A, subclause 1, the words up to 50% of the total mineral produced in a year shall be omitted. Therefore, the captive mine owners are completely free now to transfer and sell, dispatch the entirety of their mines they produce, whether they want to use it for captive purposes or not. Therefore, on the one hand, the ease of doing business and to make the market more friendly to you, imposing too many restrictions on the one hand, removing them. The other hand, a more ordered and regulated environment where I know what is happening to the wealth of the minerals. So the state, so therefore, can somebody be heard to argue, I mean, don't look into, tell us what we should do with the mine minerals. Now, what perhaps has happened, to conclude with this argument, that when this window of auction became and opened, the existing lessees, in order to retain their leases, so probably they might have quoted a high premium. And a high premium in order to retain the lease or to keep in a competition bid to hold that somebody else is not coming. So whatever you might have done by way of high premium, and you come and say, oh, I probably made a mistake. I have some problem. So is that a ground for challenging the rule? Therefore, it is your problem. You have to probably pay a little back. So I would conclude with that. There is, I do not find that any reasonable grounds have been made out to say either 4B cannot be construed in this manner, nor 12A is not in conformity with 4B. If 4B is rightly construed, I would say Rule 12A is entirely in consonance with Rule Section 4. Therefore, I don't think I need to counter all those judgments on whether a delegate legislation must conform to the Parent Act or not. So the doubt will arise only if we have a very difficult question to answer about 4B. I don't think there's such a difficult question to answer. And you'll also know that royalty, after all, has two twin purposes. Dispatch. Dispatch means royalty and also the supply of minerals. The twin purposes will be completely frustrated if you say, no, don't bring in dispatch in the whole connotation of sustained mineral development. I mean, thankful for your time. I'm done.
Yes. Any further argument?
My lord, we are possibly waiting for the Advocate General, my lord. We just want to know.
I don't think it's available. Is available today. Who is?
Other we can say. Where is Advocate General?
Dr. Singh, we promised to travel along with in the flight, but it did not take it.
Well, I'm sorry I missed the last part. I was just a little out of.
So there was some promise which we made to the Learned Attorney General.
No, well, it's the Learned Attorney General. Some of his these remarks have to be challenged, Manoj. I'll tell you. I left yesterday, Manoj, and I will never take him for a ride, Manoj, to speak metaphorically. I dare not do that, Manoj.
I believe the Advocate General wants some indulgence. 19.
Well, that is what it is spanned over for a pretty long time. That the whole difficulty is to remember everything and to keep among the stars for the bench also.
That's true. That's true. Can it be done like this? When the learned friends conclude their rejoinder?
I would say the innovative doctrine has now come up, has evolved. So it's something to be pondered upon. So there has been a considerable debate on the applicability of those penumbra theory. And two of the notable, I would say, the jurists, Hart and the Fullers, they are not agreeing.
True. So, would you lordship then do
My lord, it's a double-edged sword, my lord. Penumbra is a double-edged sword.
That's true. That's true. Very true. So, where it cuts is a question.
That's true.
So, learned friends probably in their rejoinder documents, as they conclude, maybe the AG can chip in and say whatever you see at that point of time.
Well, it's I was just as your lordship is. I believe the learned attorney has finished.
I'm done. I'm done.
Yeah. So, may I just take your lordship's 2 minutes?
And reminding you of your promise, you will take him.
Well, I told your lordship, I dare not take him for a ride, Wallace. He's occupying too exalted a position for me to attempt that. Now, Wallace, may I just take a couple of minutes to smoothen out the thing? Wallace, number one, I had a request, and it is only invoking an indulgence which fell from my lord some weeks ago. for our rejoinder, one way is if your lordship does sit on any Saturday on 24th or 31st, I can finish my part in a day, or less than a day. 24th and 31st are both Saturday. That's upfront one suggestion. Of course, it's entirely your lordship discretion. Otherwise, let the learned Advocate General finish. And I will try and do it on 29th, which is a little difficult for me, but I will try and finish it. If your lordships can put me on 24th or 31st, it's up to your lordship, indulgence.
But we have two other eminent senior counsel waiting to.
We are ready, my lord. We are ready whenever, and we'll
No,
come
I've checked.
physically, my lord.
I've checked the dates. I've checked that. I've talked about these dates yesterday also with Mr. Subramaniam. I couldn't get Mr. Dwivedi, but
Yeah, I have no problem. The 24th and 31st.
We'll be there. We would prefer to be there physically, my lord. Some reasons.
that's why I was saying.
constrain us.
That's why.
There-
Exactly.
No, there is no problem on our part sitting on a Saturday or a Sunday to conclude any argument. But the difficulty is the preoccupations. There are certain things which has already been committed. So that's the whole problem on 24th.
If your lordship is otherwise possible, then lordship will consider 31st, if it's possible.
Oh, I understand. Yeah, they are requesting for Saturday. That's why I'm saying no. But when he will be available, the most
He requested for 90. And Advocate General requested for 90. He can come back.
and we just ensure because the Honorable Attorney General at least has kept his commitment and has come to the court. Late overnight, yesterday, concluded the argument.
So the best way probably would be on the day when they are here, the AG can step in and say what.
Or since 19th is being mentioned, it's a good way of finishing off their arguments. Well, then we can do on a clean slate on 31st if it works for your lordships. Whichever, I don't mind. I mean, whatever.
That, how to reach their destination. That is the conclusion. Everything is convenient. Difficulty is because once we have put our efforts into it and we are deeply going into all such aspects. In the meantime, there are many matters which are coming that really distress.
Well, may I say that now that the learned attorney has finished, the Advocate General can take any date of his choice now before your lordships. He's here in Odisha before 31st, and your lordships can put us down for 31st and we'll finish it off.
We are already on 9th.
Yes, yes.
As he is not, whether he's not available on Monday or a Tuesday or a Wednesday.
Tuesday, some matters.
I'm talking about Monday, Tuesday, Wednesday, Thursday.
Thursday or Thursday.
Thursday is better.
Thursday 15th.
There are some matters where today morning I
Thursday 15th.
He's in Delhi.
So this is also a very important matter. I believe so. And he was showing a very, I would say, the concern about this. So it has to reach to its logical end. Talk to him.
I'll just.
He's in town.
He's in Delhi. I spoke to him. I think he's in some matters with.
He was in Delhi. 19th he requested, but still so lots of my grand.
Could we, lordship suggested 15th or so, find out from him.
$15 is not a SLP day. Don't worry. Mr. Singhvi, your system is muted actually. Yes.
Yes, yes, Mulus. I muted it. Mulus. I'm now again.
So 15th,
Let my learned friend do it on 15th. We have to take stock of the learned attorney's arguments. We'll make a composite note. Would my lords like to freeze our date, Mulus, if your lordships can? That will make it clear, Mulus, for your lordships calendar also and for us also.
so we are fixing on 15th, and whatever is convenient to you on 30th. Other day, don't.
31st, Mulus, will be excellent if your lordships can accommodate us. That would be excellent for us.
Why not immediately on 27, 28?
Well, it's I mean, it can be done. It's a difference of about 2 or 3 days. Manoj, it will make it safer that we do not, Manoj, juggle with your lordship's days. Difference will be 2 or 3 days. This is absolutely, Manoj, it will be blocked and most of it will finish. If at all it spills over, it will be maybe little bit, very little. But otherwise, it will be over, Manoj, from our side.
On the lighter side, all my learned friends are capable of a conspiracy against the laity.
Lord, we may not agree with the Attorney General and his submissions, but it was a great pleasure to hear him, and we listened to him with rapt attention.
Which is why we need some time, Manoj, to absorb, digest, and then rebut.
No, take your time. We don't mind. I was just thinking instead of 31st, if it can be 22nd, 27, 28, 29.
22nd.
Then Manoj, it can be 29th if your lordship will want to have it on a weekday. Though 29th
and on 19th, let it come. He has assured on 19th.
Yes,
I believe no other assignment on 19th.
So my lord is putting on 19th and 29th.
Yes.
Very
Grateful,
well.
my lord.
Attorney General.
Naturally, but the interim order will continue.
Yes.
We'll stop.
We request, my lord.
An accommodation is sought on behalf of the learned advocate.
Deeply obliged.
Deeply obliged, my lord. My lord, on a lighter note, I wanted to mention my learned friend, the Attorney General, spoke about Justice Holmes. But I also want him, my lord, to look at a decision of his, Buck versus Bell, which led to a great effect, my lord, which also led to the Second World War. Buck versus Bell.
And the most difficult part of the penumbra was during this Nazi's time. That's the World
That's
War.
right. That's right.
When the lady came forward and took a defense. So let us see.
Certainly, my lord. Certainly.
Obliged, Manus. Deeply obliged.
Obliged.
Deeply obliged.
Your Lordship, sir. Yes, it is. The interim order is extended to.
Very great.
So grateful. Yes. Let's call the next one.
Item number 6.
Hey, please. My lord.
My lords, it is in absence of the GST tribunal items.
Yes. Yes.
Item number 7. Item 6 also.
Hmm?
All the three matters.
Yes.
Item number 7.
What about item number 5? Is 4? No, this one. Oh, sure. Yes, and 6 is over. Okay. 7. 7.
That's good.
7, who is here?
Mr. Tibralam, you are not there.
Item number 7.
Oh, it is central. Central.
My lords, I am appearing on BC, my lords, for the other side.
Item number 8.
Please, your lordship.
Item number
8.
8, your lordship. The present petitioner, last occasion, your lordship has directed to the council, state council to obtain instruction. The present petitioner has challenged the cancellation of a bid under annexure 7, your lordship. The bid was
there was you submitted the certificate showing the deposit
showing
there-
the pledge, showing the pledge.
and the pledge with the superintending engineer. So
Yes.
they were doubting on the genuinity of them, and the matter was adjourned to take an instruction. Who is appearing? Where is Mr. Shubho Vikas Panda?
No.
This is not a GST matter, sir.
It is tender matter.
It's a tender matter.
Item number 8. You are confused, I think. Madam is alerted. Item 8.
But
What?
8 is very. Pass.
8.
Mr. Tripathi is available.
Where is he?
He was there. Item number 9.
My lord, I am appearing on BC.
7 days.
Have you served the copy on Mr. Arun Kumar Acharya? Oh, that's
My-
why I'm looking at it. Arun Kumar Acharya, S.
My lord, I am appearing on BC.
Acharya, S. Das. Anyhow, they are not here.
My lord, I am appearing in BC.
So why you are not responding, sir?
Sir, it was muted. Sorry, sir. Sorry, my lord. Sorry, my lord. I am appearing on BC. I have received the copy. My lord, what has happened in this case? My lord,
27 days, sir.
my lord.
Delay. We are concerned with the delay.
Yes,
We are concerned with the delay of 27 days. Tell us.
my lord. Just before the delay, I may submit.
We can't enter into the merit unless we allow the delay.
My lord,
Then we will post it for admission.
all right, my lord.
Yes. Give me it. This is an application for condonation of delay of 27 days.
27.
What is our stamp reporters? 27.
27.
Condonation of delay of 27 days in preferring the appeal beyond the period of limitation provided therefore. Application. Plan. P. Okay. It is a word in the instant application that after the disposal of the petition, as well as the review petition. Now, the review petition, the necessary opinion was
in place of Marvada Srinivasi,
why?
who is the executive officer NAC HON'BLE, Your Lordship. Because during the pendency of the content petition.
Acha, he has been
Yes, Your Lordship.
transferred.
Yes, Your Lordship. Yes, Your Lordship.
For that, the IA is filed.
Yes, Your Lordship. For that changing his name, Your Lordship.
Add or strike out any party is also, it can be exercised by the court suo motu.
Yes,
What
sir.
application?
But the last order, Your Lordship, that was before the Honorable K.R. Mahapatra and Sajay Mishra, Your Lordship.
There is a
And the last order, the order was like
This
that,
is
Your
a-
Lordship. At that time, I was unable
is
to
a
found the name of the
petition
structure. That was
you good. It's allowed, man.
deeply organized, Your Lordship.
Item 14.
In this matter, I'm praying for a not development here.
Which is now becoming complicated.
I will come prepared in this matter, but I need some time. Maybe on Monday.
The difficulty is that I don't know what to say. If this prayer is made, I leave it to your lordships. The issue is short. There's a concluded contract. There's an admission of obligation to pay. They just say that we will not pay because ultimately there was a government circular on which the price escalation clause was premised, which has been struck down by this honorable court. But the striking down was the instance of petitioner of contractor group, which say that this is not beneficial to us. It should be more. I am happy with whatever they're ready to pay me under the price escalation clause. They admit that it is payable. But only on this basis, my payment is refused, and I am facing NPA threats from the banks. That is why I have come up with urgency.
I only request my lord senior taken up immediately in the next week. They are facing an NPA. If their accounts is declared as an NPA, then the whole problem will be.
No, it's not 2 days. No, that Monday I can't.
Because the matter would be taken up on Monday. If the order is passed, then you will again take a longer time to release it. Well, the question of law is involved in this case, my lord. At least I will not be assisting your lordship properly, my lord. When a circular is passed, what would be the effect, my lord?
Well, that is
So
what
you
we.
knew it, so why you could not get yourself ready? Sorry, but I could not be ready. What is that's why only. And you knew it that this matter is appearing today. That is the predicament. I think the order was passed for fixing the. So, what is the necessity of passing an innocuous order in all the matters, fixing a date? When you cannot make yourself ready, don't you have the the calendar of your cases? Which one is coming on which day? You have to argue. I fail to understand. There should be, sir. What impression one will carry who is coming from outside? Actually, I make apology, we missed these things. It has a very strong traditions. So,
Item 15, my lord. Pleadings are completed, my lord. Your lordship may fix up a short date for hearing of the matter, my lord. Your lordship may fix up a short date.
then here, start.
My lord, arguing counsel Mr. Rai is out of station, my lord. That is why I am seeking short date for it.
Now in this matter, they will be ready. Look at. Are you ready in the matter? Not today.
Interim order, continue. Interim order is there. Interim order is there.
To continue.
Yes.
Item 16.
That 16 is a batch of 2 writ petitions. Your lordships had heard it earlier. Past interim orders, and it's coming up for final hearing. Well, I am ready to argue the matter. Only thing is, my learned friends have served on us today in the course of the court proceedings. Well, a copy of a very bulky supplementary affidavit. Well, I have not had an opportunity to go through.
Supplementary affidavit.
Yes, well,
That is pursuant to last order, your lordship. We had filed a preliminary counter affidavit. This is our.
there's no leave granted.
Sir, which pleasure is class.
Well, there's no leave granted by court. Well, if my learned friends want to rely on that, well, I will naturally have to respond. But well, if my learned friends do not rely on it, let us argue it out.
Lordship directed that in the last order itself.
There's no direction.
No. As in the liberty was there. They have filed it. And this has not also come up on record as per my instruction. At least in the noting, it's. Let this be brought up on record.
Not yet come.
Well, I'm ready to argue, but if my learned, I've not had a chance to go through the affidavit.
So, when have you filed?
Lordship, today.
No, served today. I don't think it's filed yet.
No, when have you filed in the registry? You have filed in the registry.
Lordship, I filed today. Today. In the morning, it's been filed.
Anyhow, I do not want to say anything.
Well, then may I use a response in 7 days? 7 days.
It is submitted by the council appearing for the
Item 17.
Supplementary contract, we have filed it in form of an additional.
Yes.
I'm sorry. Well, in the earlier matter, there was an interim order, that has to
Till the next date of June.
interim order.
Yes.
It may please your lordship, I am for the petitioner. Actually, they ask you to file the counter affidavit, and the state has taken repeated adjournments to file the counter affidavit. They have not filed. From the noting,
Contempt the state. Why? Contempt is against a person.
Yes, it is a person, but actually the Lawrence State Council is appearing for the contemner.
Who is appearing in this matter? Mr. S. Dash. Then Miss Aishwarya Das.
No such compliance affidavit. I have not at least received the copy of the compliance affidavit.
Mr. Das, Mr. Das, are you aware of order dated 13/5/25 and 12/12/25? 13/5/25 is not complied with by you. Para 4.
What is that?
We find that after notice is issued and opportunity to file the counter affidavit is not, the counter may be wrong, but the counter affidavit is not extended to the alleged contemner. We therefore direct the alleged contemners to file counter affidavit within 2 weeks after reopening of the court. Following the summer vacation, it goes without saying that the documents sought to be placed before us shall be disclosed in the said counter affidavit. Thereafter, another
Extension was done.
additional standing counsel seeks further extension of time to file counter affidavit. Let the counter affidavit be filed within a period of 2 weeks from date, that is 12/12/2025. Now it is contempt. You have to comply our orders, not like this. Very soon.
It's about translation.
13/5/2000. Then another that order was not complied. Also on 12/12/2025, another opportunity was granted to the parties to file affidavit at the request of
The direction of the honorable court. What is the meaning of the substantial compliance? Why not the fullest compliance?
It has already been complied. Pursuant to the direction.
Give him a copy.
And sub copy, second post.
Actually, My lord, just I want to draw your lordship's attention to the order dated 30th January 2024 in WPC number
That is what
15551.
you are alleging that the same has been violated.
Yes, my lord.
What was the direction passed there?
The direction was passed. Mr. Muduli, para number 3, Mr. P.K. Muduli, Lawrence Additional Government Advocate appearing for the state opposite parties contended that the present writ petition is not maintainable since there is
I am asking for ultimate direction.
ultimate direction is that they have to dispose of it as an appeal under section 46 of the stamp rules.
Oh, it's over.
In view of the above, this court directs the authority to take a decision on the objections filed by the petitioner within a period of 2 months in accordance with the delay.
Anyhow,
They have
you have disposed of? Yes. There's nothing left.
My lord, copy the
complied with
Copy.
30th January 2024 order. Maybe delayed. You have stated in your affidavit.
Give a copy. We are disposing of.
Item 18.
My lord, one time may be given so that we will file a.
What file? They have disposed of the appeal.
No.
The order is there.
Actually, they are telling it, but that is not a substantial compliance.
That is a substantial.
Sir, the direction was in view of the above. This court directs the authority to take a decision on the objections filed by the petitioner within a period of 2 months in accordance with law from the date of communication of this order. This is the order. So they say that they have complied with, they have taken your objections into account, and they have.
Oh. Actually, my lord, what happened? They have to dispose of in terms of the section 46 of the stamp rules.
In accordance with law.
Specifically, they have mentioned, your lordship mentioned that is 46.
In accordance with law, if they have taken it, if you have any grievance, you go and challenge that order anytime.
Item 18.
Let them give the copy.
Which one is the order you have?
18.
Which one is the order?
Last direction where the government has approved.
Answer I/3.
Yes, and that's why the benchmark valuation of 22 to 24. And before that, there's no reports which talk about the inquiry that was done. And where no discrepancy was, there was no requirement for the change. That is also explained in the inquiry.
No, this proceeding was supposed to be disposed of. Have you disposed of the proceeding?
Last one, the 46 talks about appeal, and 46(3) talks about the this 46(3), the final decision of the government. Decision of the government.
We are talking about the order was to dispose of the appeal. Objection.
There's one appeal and objection. Both are considered minor.
So has been disposed of.
From this, it is not emanating.
Since we don't have any copy, actually, I am not in a position to tell whether it has been complied or the honorable court's order has been really substantially complied.
We are in a position to ascertain. My brother is taking care of that. Don't worry. If he finds that it is disposed of, he will tell you is disposed of.
Just 7 days time may kindly be.
Which file is this?
H/3
সেটা তো মেরিট উপরে কথা বলছি এটি কোর্ট অর্ডারটা কোন ভাবে কথা সেটা না
Objection filed by petition to the period of 2 months. The order number 51. Accordingly, committee was set up under.
say at your request in para 3. At your request, we directed You have said that you will consider under rule 46,
Yes.
right? So he has an alternative remedy under rule 46, right? So where have you disposed his case?
No, it is objection which has to be disposed of by the objection, only objection. There is no appeal is recorded. Only objection.
Under 46.
Only the objection.
Para 2 was the objection.
He says
Para 2, it is objection. Para 3, you have said that there is an alternative remedy under 46, rule 46. Then we have directed that objection in accordance with law. That means which you have.
the objection has been considered, and they have already done
Yes, sir.
the evaluation. This is already been
46 2.
yes, it has been
They have
examined, and they have now enhanced. So they have come. They have come. They have complied. Give them a copy. They have complied.
Man, only
Once was enhancement of the benchmark value. They have already enhanced.
Requirement. That period was.
You have decided benchmark valuation which was there. You have constituted the authority under 46, and he has taken a decision.
actually in that proceeding we have not been called upon to have our say.
Challenge it. Challenge it. The order has been complied. It's a contempt.
Okay.
We are not going to re-hear the matter. We will simply see whether the order has been implemented. The direction was to dispose of the objection within a time in accordance with law.
Yes, I bow out.
Disposed of.
Yes, my
May
lord.
be beyond the time. That's some kind of a contemptuous act. We will condone. We do not see that's a technical.
My lord, just I bow down. The only thing is that 7 days time may kindly be given so that I can get the copy, go through it for my satisfaction. Even I can, in that case, I will fairly concede and also I will fairly advise my
The contempt.
client.
We have seen that. Give him a. Why don't you give him a copy? Your juniors are there. Don't worry.
No, I am supposed to be absent from Kotak on Monday. Tuesday, that will be 13th.
Tuesday.
Yeah. Tuesday.
Item 18.
For non-compliance of the lordship's order under Annex 1.
18.
Wherein
Yeah,
the lordship
No, it is the WA. What is Oh, yeah, this is 18.
18.
We have already issued notice to the enforcer to quit, my lord. By 1812, they have to directed to quit the place as per provisions of.
What? 1812 gone.
So today I telephoned to Tahsildar, he was not available. Additional Tahsil available. He says that I have recently joined. I will take instruction and tell you tomorrow.
Order was passed.
Let it come. Let it come. We have already taken
Tuesday, let him take a step. Let him come. Him come on Tuesday.
Place.
Let us see. Now, in the meantime, contact. He has recently joined.
Item 19.
19 may please your lordship. Your lordship may recollect that matter. Your lordship issued notice in the appeal, and the contempt court is proceeding against the appellant. And I am unfortunately that the respondent not received the notice.
Undelivered notice.
Not claimed.
Not claimed, my lord. I have taken the.
It's a good service.
Yes, my lord.
It's a good service. Not claimed is a good service. Where is the judgment of the Supreme Court?
Unclaimed. Unclaimed.
No, not claimed. Not claimed. Means he was there. Intimation was given, but he did not come forward. PIR 1989 Supreme Court. Right. BP Pathak's case. 88 or 18. Bring that. That the not claimed is a good service. I'll bring it. To record. Was there? Last matter. You had to 88 or AI or 1989 or 88.
Number 8 was a pass it over. The government council was absent at that time, at the time of pass.
Yes, let us go to the Passover first.
Pastor matter item number 7.
My lords, I am appearing for in VC, my lords, for the department.
Yes.
I'm appearing for the petitioner. That's it's 734B.
Yes.
Item number 8.
Item number 8, your lordship. The
Who is for the state?
I am appearing. That's the last order. Order number 2.
Order number 2. Oh. In your favor?
But actually, they sought for an adjournment for a clarification.
Oh, yes. Have you? No.
no. The
Oh, clarification. You asked for a adjournment. Yes.
this
Yes.
case, your
Have
lordship,
you taken? Can you come and certify on affidavit that this is a genuine certificate?
yes, I will file the certificate. Let it be.
And your claim was that it is never filed. Sure.
No, it was a file. Lordship, on
No, you'll
the
have to give on affidavit.
Yes, I will give an affidavit.
Give.
Another sort date kindly be fixed so that
Yes.
the person will file an affidavit.
For filing an affidavit.
Short date kindly. Specific date.
1
date
week.
kind.
1 week.
Yes.
That's all.
The last matter 19.
19 has been done. 19 is over. Not claimed. Oh, have you got that judgment? Anyhow.
That is 2023 by the Registrar of Supreme Court.
No, this is the registrar. This is for the judgment of the court. It is a
Hello.
registrar's order.
Yes, my lord. As per
Priyanka-
the office report,
Priyanka-
may I read? My lord?
I think Priyanka Kumari has referred to one of the earlier Supreme Court judge. Priyanka Kumari is not Supreme Court judge. That is a Registrar of Supreme Court.
Yes, my lord, that earlier judgment, 99-7 SEC 510, my lord. Ajit Seeds Limited versus
Unclaimed.
Not claimed or not claimed.
unclaimed.
Unclaimed. And that I
Did you not get the old judgment of 88, 89? BP Pathak judgment, you did not get it.
The latest which came up, my lord, which refers to a 1999
No,
Supreme Court.
BP Pathak,
99-7
if I
SEC.
correctly
That,
remember the name.
K. Bhaskaran versus
There's two, my lord, which has been referred to 1999. I'll just check your lordship's
Yes,
order.
BP Pathak.
My lord, I'll just check it, my lord. Here, my lord, they only refer to two old ones, 1999 Supreme Court and 2014. My lord. I'll check, my lord, 1989, my lordship.
What is 1999 judgment?
Well, the 1999 is K. Bhaskaran versus Sankaran Vaidyan Balan.
return on claim.
Anyhow, if it is there, then good service, and then keep it for admission on the other.
My lord, in this case, I am appearing for the respondent number 1 before in the content petition.
Sir, what are you doing?
My lord,
We are waiting for you.
No, my lord, my lord, the notice was not served on the person concerned.
Our
And here is-
department says it was not claimed.
My lord, may kindly see the address to which it was sent.
Sir, not claimed means absolutely at the address which is shown in the record.
My lord, your lordship, kindly see the writ appeal has been filed at the address where the petitioner is continuing at another place. And this
pursuing the contempt application.
The notice was sent on that address. Yes, my lord. Your lordship,
Today I will solve that.
your lordship, call this matter next week. I will file.
You are appearing for the.
Yes, ma'am. I am filing.
Blood one prayer.
One more prayer.
Protection be given. Blood the matter has been fixed to Monday. Contempt application.
This will appear on Monday.
Uh,
I know, before the appropriate bench.
Mr. Biswakarma.
You serve the copy today.
Yes, ma'am. Yes.
On behalf of respondent.
Respondent number 1.
Respondent number 1.
There is only one respondent.
Yes,
yes.
That is
why one?
Copy of writ appeal be served on Mr. Biswakarma by Prabhakar.
Condonation application as well as the
Yes.
both.
I and W.
It's a matter of
Both you take.
delay of 900 days.
One observation: if I pray before the contempt court, the matter may be adjourned to some.
No.
But consecutively, the
900 days delay
has been directed appear in person.
900?
900 days delay. And your lordship, the latest judgment of the Honorable Apex Court.